committee shall do well to examine finally adjudicate issue in a your Lordship and your Lordship may see the earlier order, Annex 3, by the very same. May I take your Lordships?
Yes.
Let's take your Lordship, page 100.
Yes.
That's the just that was an order prior to that. Your Lordship may see there it says that the scrutiny committee is the only authority we can decide. Thereafter, at page 102, that it is open for the parties to the complainant was here says that you inform. We have already informed 171.
What is the harm? What is the harm in actually informing again?
But I will have no. I will complete minutes. But the inquiry should continue. That it is continuing from the stage because I have nothing more, a single document or a single sentence more to write.
Just you have to page 171. Come down to 171.
Minutes.
You addressed it to whom?
This is addressed, this is pursuant to 170. 170 is the notice, we answer. Verification of genuine caste.
To whom have you addressed this?
This is, the letter has been written by the Joint Director. Your Lordship may say, previous.
To whom have you addressed?
Who is the Secretary of the Scrutiny Committee, Chairman?
No, sir.
Your Lordship may see 170.
171, to whom have you addressed? 171, who's the person to whom you have sent this letter?
Joint Director SSD, Office of the Revenue Judicial Central Division, Cuttack.
All you have to do is same letter you have to send now to the scrutiny level committee, right? State level scrutiny committee. You're finding it so difficult, just the same letter to send it to the state level scrutiny level committee. Is it going to cause you so much difficulty?
I will not comply the order, but the only thing is that it should not be treated as a face complaint. That your Lordship may clarify, I have nothing. Because your Lordship sees 170, it was issued by the person we have addressed to that committee.
You have brought this upon yourself. You delayed complying with the impugned order for 9 months, 11 months now. You brought this upon yourself.
Your Lordship may see 170, the issued by Srimati Dharti Mishra OS Joint Director on behalf of the Scrutiny Committee, and accordingly it has been answered, your Lordships, 171. The very
So this is the only ground on which you have filed this appeal, that I should not be made to send another complaint, correct?
But if it is said,
I've already sent a letter.
Teacher a face complaint.
I've already sent a letter. Who is the single judge to ask me to send another letter?
No.
So let us file an appeal.
That will
Let us file an appeal. Let's keep it pending. Then for 11 months, we don't do nothing. How can a single judge ask me to write another letter? This is the only ground.
That's what has happened, that the Toaster Authority apprehends that once we write, it may be treated as a face complaint.
No.
Because she will take that because there is an order and it has been, so it has to be taken, the entire process has to be again. That's the only thing. Because if you have Karship in one line,
is this the only ground?
Our apprehension is that the moment we give a second complaint, it will be registered a face complaint, and it will face process will continue. That's my apprehension.
Has the single judge made it time bound, or he has not made it time bound?
Both the orders there are time bound. 3 months.
So what is your apprehension when it is time bound? What can be your apprehension?
But the previous order was also 3 months. The scrutiny committee, because scrutiny committee, they takes minimum 1 month or 2 months is the minimum adjournment by them. They do in spite of all the reports, it won't happen because it's a expert body from the whole of the state of Orissa. They sit and in a particular day and they decide. My apprehension is that, I'm sorry, this is the...
waste. I'm very surprised that Paradip Port Trust is prepared to waste so much resources, time, everything. Very surprising.
Because we have said, Millards, in the topic that we this is our apprehension. Your Lordship may clarify in one line the matter.
What did you want to say?
Your Lordships, may I just say actually what's the reason why they filed it? Two strangers filed before the National Commission for Scheduled Tribes. And that was forwarded to Paradip Port Trust. And the background is that few employees are having quarrel under an Atrocities Act case. So it arises from there, that background. This person is facing this. And then what happens is they don't intimate that to me. They should have straight under the act forwarded to the committee. They don't do so. They write to the ADM directly. ADM then writes to the sub-collector. Sub-collector, the Tehsildar, and they create all these documents against me without my participation. Then they issue a disciplinary action. That got stayed in the first matter. Court said nothing doing. You don't have jurisdiction to enter into re-verification arena in view of that judgment of Supreme Court as well as the act. So it stopped it. In my second writ, exactly that's what I said, that if they have a complaint, let them forward it under Section 6 and the materials
where was the occasion to file another writ petition?
Yeah, Luscious, because the material which they had created against me, all that I wanted, let that material not be taken into consideration. Let everything be decided afresh by the committee without being affected by this. That's why the court said, fine, in all view of the matter, even if you have whatever you have to say or whatever, just be before the committee. So there was no occasion of anything restarting. All that they want to do is save that material, because if the scrutiny committee goes in my favor, they still have that materials in their hand.
No.
That's all that's why they don't want to go before the committee. But the act clearly says the moment an appointing authority gets any complaint, you approach the committee. All that they're doing is they don't want to go there. Because once they go there, obviously all the materials which they had created prior to the committee almost becomes meaningless. But they want to save it. And that's what I'm saying. And those two strangers are also the same person who have again approached the scrutiny committee. So those persons only have initiated this and is landed.
This 3/4/2023 is on the complaint of those private persons.
Yes, Your Lordship.
So basically, when they give a formal complaint, it will be tagged with this.
Yes, Your Lordship.
That's all. Nothing else.
And actually, what happens is before the scrutiny committee, the whole ethnological thing is seen. What was their language? Where did they hail from? Or what were their customs? So, Your Lordships, in fact, so it's a full-fledged procedure. They go into the reality of the person. You are depriving that person from the status, which he enjoyed from his forefathers' time. So, that's a full-fledged hearing and happens, and everything is noted down. How they lived, what was their customs regarding death, marriage, everything they look into. So, that's why I'm saying, these documents which you created behind my back should not affect the scrutiny committee, and you also be there. So that becomes binding on them. They don't want it to be binding on them. That's why they don't want to succumb to that jurisdiction.
That's not the correct submission. Your Lordship, see Annexure 7/152. We have given everything to him. The same thing has been from 30th 12. Millards has been communicated. All the documents has been communicated. Millards, we cannot make a inquiry. We just, when we got the information, National SC/ST Commission asks us to reply. Then we asked for the district magistrate. What about this caste certificate he has submitted? They said that it's not, he is not a ST, he is a Kamara. Thereafter, Millards, by the time we received from the SL state level scrutiny committee, and Millards, we submitted him the report, but then the writ petition was closed with that within 3 months, which we decided. He filed a first writ petition challenging the documents. He has never questioned in that writ petition that the Paradip Port should give again. He has questioned that these documents must be quashed. And Millards, the order directed. We are cooperating the scrutiny committee. Only our apprehension is that it may be treated as a fresh complaint. If it is Millards, that is the apprehension that we approach your Lordship. Because everything has been supplied to the SLG, and the matter is staged as the stage 3 because the police verification is over. He has submitted the show cause to the police verification, and thereafter the personal hearing day 1 is completed, day 2 is completed, and day 3 has been fixed.
Your Lordship, section 6(2), I think that's also the single judge has taken note of that section. Clearly says that they had to approach, they should not have done what they did.
No.
Those documents should not have been created behind my back.
What creation will not?
I mean, you wrote to the ADM.
That's the, let's say he's in a scheduled tribe. If anybody, then he says that he's a higher caste people and people are fearing him. Because
the Madhuri Patil case also is very clear with detailed guidelines.
Against the people that if you do something, then
or the Paradip Port Trust (PPT) has in this writ appeal challenged an order dated 20th May 2022, passed by the learned single judge, disposing of petition civil 9312 of 2022, filed by respondent number 1, Shri Pramod Kumar Bindani. The background to the present appeal is that respondent number 1 was appointed as an assistant engineer (civil) in PPT on 14 September 1991 on the basis of his producing, inter alia on the basis of his producing a caste certificate showing him as belonging to the scheduled tribe (ST) category. Subsequently, he was promoted as executive engineer on 20th March 2002 in terms of the roster point reserved for the ST category. Full stop. In terms of the said certificate, he belonged to the single quotes Kolahar tribe. Stop. It appears that respondent 1 preferred a complaint under the SC and ST Prevention of Atrocities Act against certain persons. As part of those proceedings, the DSP, Deputy Superintendent of Police (DSP) Jagat Singhpur, referred the certificates submitted by respondent 1 and the person against whom the complaint was preferred for verification to the revenue authorities. Full stop. It appears that some inquiry was conducted in that regard, the details of which need not be set out in the present order. Paragraph. Separately, two private persons appear to have approached the National Commission for Scheduled Tribe, NCST, New Delhi, making a complaint against respondent 1, questioning the genuineness of the certificate on which showed him to be belonging to the ST. Full stop. A letter was sent by the NCST to the PPT, on the basis of which PPT wrote a letter on 23rd April 2021 to the District Magistrate Mayurbhanj, asking him to inquire into the matter and send a report. Full stop. The ADM Mayurbhanj appears to have submitted a report on 21st October 2021, stating inter alia that the internal inquiry revealed that the caste of the father of respondent 1 was mentioned as single quotes Kamara, which belongs to the SCBC/OBC category. On this basis, a show cause notice was issued to respondent 1 by PPT on 29 October 2021, which was challenged by him in Writ Petition Civil 34695 for 2021 in this court. Full stop. In the said writ petition, one of the contentions raised by respondent 1 was that the inquiries and the reports had come about without issuing any notice to respondent 1 and without his participation. And therefore, that the only authority authorized to inquire into the genuineness of such certificate was the State Level Scrutiny Committee, SLSC. Paragraph. Accepting that plea, an order was passed to the learned single judge on 28 March 2022. Against respondent 1 should have forwarded it to the SLSC for an inquiry instead of straightaway issuing a show cause notice to him. Full stop. A direction was issued that no coercive action would be taken against respondent 1, open quotation, without final adjudication, unquote, by the SLSC. Paragraph. Respondent 1 filed a second writ petition, being Writ Petition Civil 9312 of 2022. stating that the SLSC would have to go by the provisions of the Odisha scheduled castes, scheduled tribes, and backward classes. Bracket regulation of issuance and verification of caste certificates, bracket Act 2011.
Your Lordship, it will be 2012. I think that clarification has come from the government.
I think 2012 bracket.
Following page, Your Lordship.
Yeah, the 2012 Act. As well as the judgment of the Supreme Court in Madhuri Patil versus Additional Commissioner Tribal Development 1994, 6 SEC 241. To stop the apprehension expressed by respondent 1 was that the materials gathered behind the back of respondent 1 should not form the basis of the inquiry by the SLSC and therefore should be excluded from consideration, as those materials were gathered without following the provisions of the 2012 Act and the principles laid down in Madhuri Patil Supra. Disposing of this second writ petition, the impugned order was passed with the learned single judge on 20th May 2022. Directing that EPT will forward the complaint to the SLSC, and on receipt of the complaint, the SLSC will examine it and finally adjudicate the issue in accordance with law by providing an opportunity of hearing to the affected parties, including respondent 1. Open quotation, within a period of 3 months from the date of production of certified copy of this order. Unquote. PPT was asked not to take coercive action against respondent 1. Open quotation, till the matter is finally adjudicated by the SLSC. Unquote. The parties were directed to cooperate in the early conclusion of the proceedings by the SLSC. Paragraph. Mr. Nanda, learned counsel appearing for the appellant PPT, submitted that since the PPT had already forwarded a complaint on 30th December 2021 to the Joint Director SSD from the Office of the Revenue Divisional Commissioner for verification of the genuineness of the certificate produced by respondent 1. It should not be asked again to forward a complaint to the SLSC, as that would mean that the entire process of inquiry would have to start afresh. Paragraph. When pointedly asked by the court what real prejudice would be caused to the PPT if it were to comply with the impugned order of the learned single judge, Mr. Nanda replied that the inquiry may take an indefinitely long time and therefore delay proceedings. Paragraph. The court finds that the impugned order has made the entire proceedings time-bound. Full stop. The learned single judge appears to be conscious of the fact that the inquiry has to be concluded within a short time frame and has therefore specifically directed that within 3 months of the receipt of the complaint from PPT, the SLSC would conclude its proceedings. Full stop. Mr. Nanda produced a letter dated 3rd April 2023 from the Joint Director SSD to the director of the what is this SCSTRTI? What is this body? What is this SCSTRTI? To the director SCSTRTI, informing him of the sitting of the SLSC on 30th April 2023 and requiring him to attend the meeting. So it is obvious that if the PPT were to forward its complaint to the SLSC as directed by the learned single judge, it would have to be examined along with the aforementioned pending proceedings concerning respondent number 1, which is already being taken up by the SLSC. Stop. Even at that score, therefore, no prejudice can be said to be caused to the PPT. Paragraph. Since the directions issued by the learned single judge are to be implemented in a time-bound manner, the court sees no ground to further clarify the said order. Full stop. No grounds are made out for interference with the Indian order of the learned single judge. The writ appeal is accordingly dismissed.
If that body is Scheduled Caste, Scheduled Tribes Research and Training Institute. They are also part.
Research and Training Institute, correct. Or
Supplementary state item number
Pardon
2.
me, Lord. I'm extremely sorry to disturb your Lordship's vote. Your Lordship, if your Lordship remember on 4, my Lords entrusted this matter for reconnection of electricity at the instance of landowners. Electricity has been disconnected to a building having 2046.
You can't mention some matter 1110.
So what happened? Well, they're out of electricity connection, my Lord. And the matter was fixed to today. And because of that, court is not functioning.
Mention at least at the end of the board, or
Maybe taken over.
give a memo or a slip or something.
I'm giving, my Lord.
Not like this. You're a
Sorry,
seasoned
sir.
lawyer.
Excuse.
Item number 2.
May I please your lordships? Item number 2. Madam. The petitioner has been filed this WA number 579 of 23 to set aside the judgment passed by the Honorable Single Judge, order on dated 21/2/23, bearing WPC number 21/21/3 of 2017. My lord.
Yes, please. Carry on.
Your lordship, the order has been annexed as 1. The petitioner is a meritorious student, my lord, and appeared the Odisha Homeopathy Medical Service on dated 29/1/2017, which was conducted by OPSC Orissa Cuttack. In this examination, 3 marks has been given correct answer, but opposite party has been wrongfully marking the answer key number 10, 97 and 100, by which the petitioner deprived for getting just 3 marks. Your lordships, my prayer is to set aside the judgment which has been passed by the Honorable Single Judge on dated 21/2/23, which has been annexed and 1, my lord.
On what ground, madam? What are the grounds on you want on which you're challenging it?
Yes, sorry, my lord.
On what ground you have challenged this? Challenge the finding of the learned single judge.
Your lordship, only for 3 marks. Can I say in Odia, ma'am?
Yes, yes. Yes, count.
Your lordship, obliged. Grounds.
कौन ground ଆପଣଙ୍କର?
What are the grounds?
Your Lordship, when the petitioner challenged the answer given in answer key for question number 10, 97 and 100 is incorrect and annex the correct answer from the textbook White Annexer 8 series.
Read petition kind dismiss ହେଇଛି.
Your Lordship, no.
What is wrong in the order? Please, page 11.
Allow me some time for better
Okay.
preparation.
Counsel for the appellant. I don't know whether you will follow what I'm now going to tell you. What you need to do is study the impugned order, which is the order against which you have come in appeal. All right.
Yes, ma'am.
Find out what are the reasons given by that single judge for dismissing your writ petition.
My lord.
Then try and tell us why those reasons are erroneous.
Yes, my
That
lord.
is why what you have to do in an appeal. All right.
Yes, my lord.
You see, counsel for the appellant needs some time to prepare and address arguments. List on. (16th May).
Item number 3.
My lord, item number 3, non-consideration of my
Oh, bless you.
representation. But may I suggest with your lordship's permission, it was in 2020. Your
Make a
lordship may
fresh one.
allow me to
Make
file
a fresh representation. All right. Counsel for the petitioner seeks leave to withdraw the present petition with liberty to make a fresh representation to account for any subsequent developments, if any. Disposed of is withdrawn with liberty is granted.
within a period of my lord. I'll make
No, if you make it, you say, and to follow up on such, and after following up on such a presentation to seek appropriation. All right.
oblex.
Item number 4.
May I please your lordship, my lord, I am on BC, my lord, I beg apology. My lord, the present writ petitioner has filed the application under annexure and before the Tahsildar Baliapal for initiation of the proceeding under Opili Act as the encroachers occupied the public road, my lord. And the petition has been submitted before the Tahsildar Baliapal since October 2022, my lord.
Where is that representation, sir?
Representation under annexure 1 and the postal receipt at last page 15, page 15.
All right. The petitioner's representation, annexure 1, will be examined by the sub-collector.
Tahsildar
Tahsildar
Baliapal.
All right, Tahsildar Baliapal. And after notice to the petitioner as well as opposite parties 5, 6, and 7, and giving them a hearing, a reasoned order shall be passed not later than 15 June and communicated to the parties within a week thereafter. The court clarifies it has not expressed any view in the matter.
Obliged.
Item number 5.
And please, your lordship, when it here the petitioner is challenging the action of the opposite parties for not taking any action against the opposite party number 3, who has forcefully and illegally constructed a house over the government land, my lord. And for that, I have given a representation before the sub-collector, which is at running page 17. And after that representation, sub-collector has directed to the Tahsildar.
All right.
To-
It
to
is
re-
stated that although the petitioner is acting on the petitioner's representation, the sub-collector had sent a communication on 9 September 2021 to the Tahsildar Kentrapada for inquiring into the matter. No action has been taken till date. Paragraph is directed that the Tahsildar Kentrapada will, after examining the complaint of the petitioner and issuing notice to the petitioner as well as opposite party number 3 and giving them a hearing, pass a reasoned order thereon, not later than again 15 June, communicate to the parties within a week thereafter. The court clarifies it is not expressed.
Item number 6.
May I please, your lordship? My lord, despite the direction of the London Sub-Divisional Magistrate, initiated Sub-Divisional Magistrate Khorda, the order under Annexure 1, my lord, passed under section 133 CRPC, the Tahsilar Bolgod is setting out the matter. Therefore, I pray your lordship to direct the Tahsilar to implement the order of the sub-divisional magistrate.
Not an executing court, sir.
That is the sub-collector.
And this was passed 4 years ago.
That is
After 4 years, you suddenly wake up and say, let's go to the High Court to execute this order.
Then I will file a fresh representation.
Counsel, the petitioner seeks leave to withdraw the present petition to seek other appropriate remedies as may be available to the petitioner in accordance with law. Disposed of as withdrawn with liberty spread.
Item number 7.
May I please, your lordship? This may pray for 1 week time, your lordship, to remove the defects, your lordship, as per the SR point out.
No, just tell us what the matter is about.
Yes, my lord. So, petitioner challenges the inaction of the opposite parties, your lordship, under Annexure 5, your lordship. Under Annexure 5, the lordship has directed to the Additional Secretary cum Director, State GA Department, including the BDA Development Authority and AIMS, Bhubaneswar, to consider the petitioner representation, your lordship.
Yeah, they can't. Don't file another writ petition for that.
Yes.
You have to file a contempt.
But lordship,
You have to file a contempt, madam.
Liberty may be granted to.
Counsel, the petitioner seeks leave to withdraw the present petition with liberty to file a contempt petition to challenge the non-implementation of the earlier order passed by this board. Disposed of is withdrawn with liberty spread.
Item number 8.
May I please, your lordship, I am on virtual mode, Milords.
Yes, please.
Because here the small prayer is a road which leads to Dhenkanal town from the national highway has been encroached by both sides. If your lordship will kindly turn to Annexure 4, my grievances will be meted there. Annexure 4, Milords. A letter of the executive officer, Dhenkanal municipality, by the superintendent engineer to the executive officer to remove the encroachment.
Mention some encroaches. Mr. Das, you have to mention who the encroaches are.
He knows. There are many encroachers.
No, who knows?
Collector, executive. Your lordship, kindly see. That is a road leading about 3 kilometers, Milords.
Yes.
If your lordship has ever gone to Dhenkanal town.
No, I have not, sir. I have not.
Your lordship has gone to all the courts.
Correct. Unfortunately, I have not gone to this place.
But this place is a very important road.
Okay.
From here, you go to the inside of the Dhenkanal, the Kapilas, also the other important places of Dhenkanal. The road has been and all important places, including bus stand, court, we have to pass through this road.
Correct.
The government is, the executive engineer has, superintendent engineer is trying to expand the road. He has asked the executive officer to remove the encroachment.
Yes.
They are not doing it. That is a simple grievance, Milords.
No, the grievance for you may be simple, sir. For all those people who you say are encroaches, the real trouble starts now.
No, Milords,
they will suddenly be shown a order passed by the High Court on the submission of Mr. Shaktidhar Das and say, now you have to vacate tomorrow morning. Then they'll turn around and say, why were we not told in advance?
No, I am only saying your lordship direct the authority.
Imagine yourself as a lawyer for one of those encroachers. What will you say?
I have never encroached.
You will say, what is this High Court? How could they pass an order like this? They don't know the basic principles of natural justice.
Then
no notice to me.
Your lordship
will you not say that? The next morning you will be mentioning the matter before me, Mr. Das.
Your lordship kindly
saying what kind of an order have you passed?
Your lordship kindly ask the executive officer. But he will give the details of the encroachment.
No. He will then include 3 of his friends. He will exclude 3 of his friends and include 3 of his enemies. Then what will you do?
No, he is the authority. It is the duty of the authorities.
Everything was functioning perfectly well. No court need to do any work, sir. See, the problem is this. This is what I've been insisting on all these matters. At least a sampling of encroachers, if we know who they are, then action can be started.
Then your lordship, give me some time. I will try to give.
No, you withdraw. You make a proper inquiry, sir, for that.
If I will give the names.
No, whoever, not you, not Mr. Das. I'm not even suggesting you should do it. Your client will do it.
My clients, if they do that, they will be beaten up on the road.
That's the whole point.
Because somebody will encroach. Who will
your client says, let the others be beaten up, let me not be beaten up.
No, no, but yeah, we did
When they go with bulldozers, clearly the others will be facing the music, correct?
It is the duty of the authorities to make the road
Perfectly correct, sir. On that, there is no problem. But we should know they should also know whom to act against.
They know it because they know it.
No. The problem is actually they're watching too much television. Everywhere, bulldozers are there everywhere.
No, not
they're saying such a simple thing. Just take a bulldozer before somebody's house and just demolish it.
No,
very simple.
The executive officer find out the encroachers and give them notice.
No, we should know who they are, sir. Otherwise, again, we will be compounding the error. Without giving them advance notice, if you simply pass.
They will give them notice and thereafter they will take action.
But we need to know the names, sir. We need to know some names at least.
Then your lordship.
Mr. Das seeks leave to withdraw the present petition with liberty to ascertain the names of at least few of the alleged encroachers. And after making a fresh representation to the authorities and naming such persons and following up with such representation to seek appropriate remedies in accordance. Disposed of is withdrawn with liberty paid.
Item number 9.
Number 9, your lordships had asked the office to serve a copy upon me to take instruction, but as Mr. Tanmay Mishra was handling the matter before single bench, he will assist your lordships.
Yes, please.
My lord, I am on VC, my lord.
Yes.
Your lordship issued notice on 21/11/2022, both on the writ appeal and ground of delay, 17 days delay, my lord, for filing the writ appeal, my lord.
Yes. Yes, sir. What is the delay? Tell us now.
17 days delay, my lord.
So delay can be controlled. All right. Delay is controlled. Now go on to the merits. So you gave a resignation letter.
My lord. Before withdrawal, before acceptance, I have given the withdrawal letter, my lord. My lord, son of the appellant was falsely implicated.
No. Just give us the sequence. When did you resign? You resigned on 26th October 2005.
My lord. I given, my lord, thereafter on 28/10/2005, I requested for leave. And 19/11/2005, the chief manager intimated the petitioner that only casual leave will be admissible. That is Annexure 1. And 28/12/2005, Annexure 2, petitioner sent a letter for withdrawal of resignation. Lordship, kindly see Annexure 1 at page 10. After the ground for resignation is the son of the appellant was forcibly was implicated in Damanjodi PS case number, and he was minor and arrested. And on being suspicious, the police arrested 14 years old minor son of the appellant on 26/10/2005 when the appellant was discharging his duty as Sergeant Grade 3. On the basis of my lord said affair, the appellant was severely beaten by his fellow employees and was forced to tender his resignation on 26/10/2005. And 2 days after, on 28/10/2005, I wrote a letter for granting leave, my lord. And Annexure 1 on 19/11/2005, the chief manager clarified that CL will be admissible. And thereafter, on 28/12/2005, Annexure 2, I have requested to withdraw my resignation since my life was in danger. I requested to, after reinstatement, to transfer me. The Honorable Single Judge held that that is conditional. Request is a conditional, therefore the same is not.
When did they accept your resignation?
My resignation was accepted, my lord. That is on
10th August 2006.
2006, Annexure 5, page 14, my lord.
Oh, much later.
Much later.
Wow.
And the Union of India versus Gopal Chandra Mishra of the Constitutional Bench.
Yes. Okay, what do you say?
Here, he had, after submitting his resignation letter, he had abandoned his duty also because he submitted.
That's a separate issue, sir. That's a separate
issue. And he wrote a letter for withdrawal of his resignation.
Correct.
But that was conditional because...
It's not conditional. Just read that.
Lordship,
Let's read that
letter.
That
is at page 11.
Let's read that carefully.
Page 11. with reference to the subject cited above, I am to request Your Honor may kindly withdraw my resignation letter, which I have submitted forcefully by the people of locality during my duty period on.
So this is separate. Okay, he has now withdrawn.
No.
The first paragraph, he says I was supposed to submit a resignation.
But in the resignation letter, he has not stated that he was.
Obviously not, sir.
Yes.
That was a simple resignation letter.
Yes.
This is a withdrawal letter.
Lordship.
So the withdrawal is explaining under what circumstances he gave a resignation letter.
Lordship.
He says I was coerced into doing it. I'm withdrawing it now.
Now, next paragraph. Therefore, I fervently request Your Highness, you may kindly reinstate me to my service and transfer me to.
So he does not say that if you do not transfer, treat this resignation as withdrawal as cancelled. He does not say that. This is not a condition. This is not a condition. It's just a request.
What my humble submission is, he has clearly stated reinstate to my service and transfer to another.
It is not a condition, sir. You can easily say we are accepting the withdrawal of a resignation. The remaining request is hereby rejected. You can reply to this at least.
No,
what reply did you send to this?
No, to this no reply was sent.
Then what is this? Then what is this?
No reply was
it's completely arbitrary.
Because
this is not conditional. He is not, by no means is he saying, if you do not transfer me, please treat my withdrawal as cancelled. This is not conditional.
No, he has used a word. Lordship, kindly, I'm relying on some judgments. If Lordship, kindly.
All right.
Because a similar issue was there before the Delhi High Court in one case. Lordship, that I have given, that is at flag 1 of the judgment list of judgments I have given.
How will Dr. Lanka get a copy?
Actually, I was not aware that he is
doing. You have to send it to him on WhatsApp. You could have sent him.
Okay. No, in these judgments, I relied in before the single judge also.
I know, but he does not know you're going to cite it.
Sorry, I was not aware that he will appear virtually.
Ask your colleague if he can send him.
Lordship.
So the first judgment, Dr. Lanka, is Northern Coalfields Limited versus Satyapal Arora.
My lord.
Yes.
Here, paragraph 19, last page of the judgment.
No, what was the letter there? Let's see that.
Lordship. Here also he had requested for a transfer along with the withdrawal.
No, where is that?
Lordship.
Para 8, come to para 8.
Para 8, Lordship. In paragraph 2G of the writ petition, it is stated that the petitioner came to know that 2 ex-employees of Coal India who had retired under the VRS were extended the benefits of EVRS 98. It is alleged that there is no ex gratia payment in VRS 82. Hence, it is alleged that the petitioner amended his earlier request of voluntary retirement by writing a letter dated 21/3/2000 asking for review of his VRS application, and instead he gave 2 following alternatives. He may be posted at Delhi for a period of 1.5 years on compassionate ground.
So this was not a resignation letter, sir. This is a letter which he gave for voluntary retirement. There were 2 voluntary retirement schemes. He opted for the first one without realizing that under the second one you get an ex gratia. So he wants to now resile from the voluntary retirement offer that he made under the first scheme. This is not a resignation.
But here was a case of voluntary retirement.
So very different.
Here is a case of voluntary retirement.
So principles attaching to voluntary retirement are quite different, sir. Quite different. And there he says he may be, this is what the 2 alternatives. He may be posted at Delhi for a period of 1.5 months on compassionate ground, and the request for voluntary retirement stands withdrawn.
And then
alternatively, he may be given that voluntary retirement at the 98 scheme. So this is that therefore made conditional. The way he's worded it.
And paragraph 19 only, Your Lordship.
All right.
Paragraph 19.
All right.
Moreover, in our opinion,
correct.
The letter dated 21/2000 was not an unconditional withdrawal.
Correct.
The letter places the conditions that either the petitioner should be posted in Delhi,
right,
or should be given the benefit under EVRS.
That's correct. That's the language. That's the language used. Post me at Delhi or give me VRS 98. Therefore, it is conditional.
And paragraph 21 also is referred to the Supreme Court judgment that letter of in Prabhatri versus State of UP, the Supreme Court held that a letter of resignation must be unconditional.
No, we are not talking of withdrawal of resignation.
Lordship. There again, that issue also, Lordship, paragraph 21, a conditional resignation is no resignation in the eye of law. In our opinion, the same principle will also apply to a withdrawal of resignation.
Correct. Suppose I say I hereby withdraw my letter of resignation, provided you promote me to the next post, right? Or subject to your promoting me to the next post, or subject to your not transferring me. Those language is important. What kind of language you use is important.
And in this case, also there is one more submission for which here, why I was submitting that here, when he gave the letter of resignation, he till it is accepted, he is deemed to continue as employee. But here, in this case, he abandoned the service and he left to his parental house. And in that issue, this Honorable Supreme Court, in one case that is reported in 2014, 13 SEC 204, that the conduct of the employee is relevant. And cases like this, when he has abandoned the service, the writ petition should not be entertained. I'm giving the judgment to Lordship. Because here also the conduct is important. He, in 2006, he gave the letter of resignation. In 2005, then he gave a application for leave. We rejected the application for leave. So he is deemed to be an employee till it is accepted. He abandoned the service for that period. The judgment, Lordship, the 2014-13 SEC, paragraph 12. In the instant, paragraph 12, Your Lordship, in the instant case, the letter of acceptance clearly shows termination of the respondent's service as per his offer of resignation was not deferred to any future date. Hence, there was no requirement to relieve him of his duties. Even the peculiar facts of this case shows respondents, while on probation, had already abandoned his temporary service for almost 8 months and had not cared to report for duty in spite of several requests. In such a situation, it would be impossible to relieve an absconding employee of his duties. And if the reasoning of the High Court is accepted, such employee, even if he has tendered resignation, must be continued in service till he is actually found or till he presents himself to be relieved of his duties. Such a view would be impractical and run against public interest. So here is a case, in this case also, and here he challenged the acceptance of his resignation after 1.5 years before the High Court. But he should have approached the tribunal because since 2008 notification had come that NALCO will come under the purview of Central Administrative Tribunal. He did not approach the tribunal and straight away approached the High Court 1.5 years after the acceptance of his resignation. That notification is.
It's okay. I don't think you took this objection before the single judge. You took it?
Yes, in the note, and that notification also I have. That first.
No. Did you take this objection in your counter affidavit?
In the counter affidavit, it had not been taken because by that time
we're not entertaining that objection at this stage.
No, by that time the notification had not come when we filed the counter affidavit.
It's all right.
And later on in the note of submission, we relied on that.
No. So anyway, we will not entertain that objection at this stage.
Gotcha.
So Dr. Lenka, tell us this point about the conduct. Why did you abandon service?
I have not amended, Your Lordship. Kindly see, I have under the pressure my lord, I have submitted resignation, and 2 days after I have submitted leave application and requested the DRM by requesting the situation under which circumstances I have tendered my resignation, and they advised me to go on a leave. And after 2 days they allowed leave application, Your Lordship, kindly see. And thereafter, Annexure 1, my lord, kindly moments, my lord. Yes, 10, my lord. Yes, 10. May I read, Your Lordship, kind permission?
Yes.
Please to refer your letter dated 28/10/2005, that is after 2 days of my resignation, requesting for a grant of leave in your favor. The said letter was received through post at your end on 14/11/2005. In this connection, it is clarified here that as per the rules of the company, once the resignation is tendered by employee, no leave can be granted to him except casual leave. As such, in your case, whatever CL is due to you as on date will only be considered for sanction of receipt of your request for the same in the prescribed performance. Therefore, they accepted my leave.
No. They're in fact telling you your leave is not sanctioned, sir. Sorry. It's exactly the opposite. In fact, they're telling you you're not entitled to leave after having submitted a resignation. And they're telling if you want CL, better apply in the proper format.
My lord.
This is a rejection. This is a rejection of your request to proceed on leave.
Thereafter, in Annexure 2, my lord, simply I submitted a withdrawal and request. This is not conditional, my lord. I humble submission, my lord.
No. First, let's now stick to the first point. So after you gave your resignation on 26th October 2005,
my lord,
you simply decided to stay away, correct?
Simply decided, my lord.
You never went back to the office, sir.
My lord,
you never reported for duty.
My lord, my family and since there was a threat, my lord, because my son was arrested in a false case, and my family and my
sir, all this is not on record. The whole problem is this. In your letters to the management, you have not said all this.
My lord, in the writ petition I have stated, and in the
writ petition all comes much later, sir. Writ petition is in the court here.
My lord.
Here on what you are telling the management.
My lord. I have mentioned that forcefully.
Forcefully is neither here nor there, sir.
My lord.
Forcefully could mean 1,000 things. And that forcefully you're saying much later. You're staying away from work after 2610. After 2 months, you're withdrawing.
My lord.
You're staying away from work for 2 months.
My lord, because of the incident.
And even after withdrawal, did you report for duty? 1 minute. After withdrawal on 28/12, did you report for duty?
My lord, my minor son was arrested, my lord. Your lordship kindly see.
Sir, you're not answering the question. This is the whole problem.
Well, I am admitting, my lord.
What admitting?
That I have submitted leave application thereafter on 28th after discussing.
See, a man, in fact, if your intention is that your withdrawal, your resignation should not be acted upon, you must demonstrate by conduct that you're serious about your work.
They have not, after my...
Absolutely.
Lordship kindly see Annexure 5, that acceptance letter.
So this is all taking it too casually. This is the whole problem. They should also accept your withdrawal. They should not even ask you to come back to work. You will not come back to work. And yet 226 relief must be granted to you. How is that possible?
My lord, I have also cited the judgment of the honorable.
Judgments, there are enough judgments, sir. So there is also this judgment which Mr. Mishra is citing. It says if your conduct is such that you are not interested in work, no court will come to your rescue.
My lord, my only predicament, my lord, my minor son was arrested in a false case. Subsequently, my lord, lordship, this is my otherwise my entire family shifted, my lord. Therefore, my request was...
Sir, because you stayed away from work, your minor son's problem got resolved or got compounded?
My lord, they acquitted, he was acquitted subsequently.
Acquitted because you stayed away from work. That was the reason why the judge acquitted him. Saying as a dutiful father, he stayed at home, did not go to work. Therefore, I find no grounds to convict him, acquitted. Correct?
No, my lord.
What has that to do with this? Sorry, Dr. Lenka. See, the challenge in the present writ appeal is to an order dated 5th November 2019, passed by the learned single judge, dismissing the appellant's writ petition civil 5416 of 2008, whereby the petitioner had prayed, the appellant had prayed that an order issued by National Aluminum Company Limited, (NALCO), on 10th August 2006 accepting the resignation of the appellant as chargeman group 3 of mines and relieving him from the services of the company from 10th August 2006 bracket afternoon should be quashed. Paragraph. The brief background is that the appellant submitted a handwritten resignation letter to the company on 26th October 2005. So the appellant contends that he was under great stress as a result of his son being falsely implicated in a criminal case under section 302 read with 201 IPC. Minor son being implicated and being arrested in that case. Stop. He states that the appellant states that the appellant was severely beaten by his fellow employees and was therefore forced to tender the above resignation. Full stop. Out of fear and to protect his life, he left the place along with his family. Stop. After having submitted the resignation letter, the appellant applied for leave on 28/10/2005. Full stop. Paragraph. Apparently, it was received by post by the chief manager bracket HRD of NALCO on 14 November 2005. And within 5 days thereafter, that is on 19/11/2005, the following letter was issued to the appellant. Reproduce the letter at page 10. Paragraph. The above letter therefore made it clear to the appellant that his leave was not being sanctioned and that if he wanted to avail of casual leave, he should apply in the proper forma. Full stop. Apparently, the appellant did not do so. Full stop. It is further not in dispute that the appellant continued to stay away from work even till the issuance of the letter dated 10th August 2006 by NALCO, accepting his resignation letter. Paragraph. The appellant's contention that the withdrawal of his resignation having been tendered on 28th December 2005, much before the acceptance of his resignation by NALCO, the resignation ought not to have been accepted. And in fact, the withdrawal should have been acted upon. Stop. Paragraph. The learned single judge declined to accept the above plea on the ground that the withdrawal itself was conditional. Full stop. Applying the ratio of the decision of the Supreme Court of India in Dr. Prabha Atri versus State of UP, 2003 1 SEC 707. The learned single judge found no merit in the writ petition and dismissed it. Full stop. Reliance was also placed, reference was also made to the decision in Right, I think that's paragraph. The letter withdrawing the resignation reads as under. Take from page 11, just the letter portion. Paragraph. Mr. Mishra, learned counsel appearing for the, you say first Dr. Lanka, learned counsel appearing for the appellant, submits that the above letter was in fact not conditional, as the request for transferring the appellant to some other place was a separate request. Full stop. Paragraph. Mr. Mishra and Counsel for NALCO, on the other hand, placed reliance on the decision of the Delhi High Court in Northern Coalfields versus Satyapal Arora, 2006 87 DRJ 788 bracket DB. And Dr. Prabha Atri was the State of UP Supra to urge that even a conditional withdrawal of resignation need not be acted upon by the authority. So reliance was also placed on the decision of this court in Jagannath Patnaik with the State of Odisha 2018 2 ILR Tatak 663. Paragraph. Mr. Mishra also placed reliance on the decision in Union of India versus Hitendra Kumar Soni 2014 13 SEC 204. Where it was held that, open quotation, it would be impossible to relieve an absconding employee of his duties, unquote. And that if the reasoning of the High Court in that case were to be accepted, open quotation, such employee, even if he has tendered resignation, must be continued in service till he is actually found or till he presents himself to be relieved of his duties, unquote. Such a view, according to the Supreme Court, open quotation, would be impractical and run against larger public interest, full stop, unquote. Accordingly, Mr. Mishra submits that since the appellant has abandoned service and never reported for duty after tendering his resignation, his request for withdrawal of the resignation could not be acted upon. Paragraph. The above submissions have been considered. Full stop. While it may be correct to contend that the letter dated 28/12/2005 submitted by the appellant withdrawing his resignation could not be considered to be single quotes conditional, unquote. Fact remains that after tendering his resignation initially on 26th October 2005, the appellant never reported for duty. Full stop. On his own showing, he left the place with his family and applied for leave. And despite, full stop, despite the leave application not being accepted, he continued to remain absent from work. Full stop. Although Dr. Lenka sought to contend that during this period, the appellant was under threat to the life and safety of himself and his family, his letter withdrawing the resignation only uses the word single quotes forcefully, unquote, without adverting to any of the other circumstances. Full stop. Indeed, staying away from work without any leave being sanctioned would really bring the appellant within the category of a single quotes absconding person, unquote. And therefore, the ratio of the decision in Union of India versus Hitendra Kumar Soni, Supra, would clearly apply. Full stop. Indeed, it would not have been in larger public interest for NALCO to permit the appellant to withdraw his resignation when he simply failed to turn up for duty for months on end after tendering his resignation on 26th October 2005. Full stop. Paragraph. Consequently, the court finds no reason to accept the plea of the appellant that the withdrawal of his resignation by the letter dated 28/12/2005 ought to have been acted upon by the respondent NALCO. No grounds are made out for interference. The appeal is dismissed.
Obliged. Item number 10. Supplementary item 10.
None appears dismissed.
Supplementary list item number 11.
None appears dismissed.
Item number 12.
May I please, my lord? My lord, the file was misplaced. That's why there is filing delay in filing requisites, my lord. The same may kindly be accepted. Already filed, my lord, in the meantime.
But what is the matter about? Tell us.
There's a matter. Your lordship, please to issue notice that the toll booth matters. Without following the regulations, the toll booths have been installed, my lord.
Or at last opportunity is granted for filing requisites.
Already filed, my lord. To be accepted.
Okay, the requisites already be.
Yes,
Mr. Murthy states that the requisites have been filed on
29/3, my lord.
On 29/3/2023, belatedly. Full stop. The said requisites be utilized for fresh notice, which will be issued to the opposite parties. Returnable 28 June.
Published, my lord.
All right.
Item number 13.
My lordship, on behalf of Mr. G.S. Satpathy, kindly give some time for removal of defects.
What's the matter about, madam? Let's see that. No, already time is granted for the removal of defects. It is granted in 22nd March. Notice was issued, right? No. No. Defects have not been removed. You see. And what are these defects still? 5D, 5E. For delay, how much is delay? 1,110. All right. There's an inordinate delay of 1,110 days in filing the present appeal. And absolutely no satisfactory reasons have been given for continuation of this extraordinary delay. Stop. The writ appeal was filed on 22nd August 2022 to assail an order dated 9 July 2019 of the learned single judge. Full stop. With there being no satisfactory explanation with the delay, the court is not inclined to condone it. IA number 2750/2022 is dismissed. Consequently, the writ appeal is dismissed.
Item 14. Item number 14.
14 outsourcing 8th August.
8th August. All right.
Item number 15.
8th August.
8th August.
Item number 16.
The job contract 14th September.
14th September.
Item number 17.
$17 job contract order, 14.9.
14.9.
Item number 18.
18, my lord. This is Prabir Kumar Biswal case. Lordship may grant us liberty to withdraw with the liberty to file a review application.
All right.
Item number 19.
My lord, state is the appellant against the impugned judgment passed by the Honorable Single Judge, wherein the Honorable Single Judge has awarded compensation of 10 lakhs rupees in favor of the son of the deceased who died inside when he was in custody. The only defense which we put forth before the Honorable Single Judge is that the matter is now under inquiry by the magistrate under section 176(1)(a) of the CRPC, and the magistrate's inquiry is going on. So we must await the inquiry of the magistrate. But the Honorable Single Judge's opinion is like this. Page 96 of the appeal memo. Hence, there was necessity for this amendment to initiate inquiry by magistrate for establishing whether there was any offence committed in relation to the death. What transpires is that pendency of magisterial inquiry cannot be defence of state against the claim for compensation when death, not being natural, happened while the person was in custody. But very interestingly, your lordship will find just one day before the judgment, the magistrate SDJM Kendrapada, he submitted the report which was forwarded to us 3 days after the judgment, and that is also annexed as Annexure 8, where it is, your lordship may come to the page Annexure 8, page 6 of the final opinion of the SDJM Kendrapada. Hence, in view of the above, I am of the opinion that the death of the deceased Purnachandra Behera might have been caused due to combined effect of the asphyxias and venous congestion as a result of hanging, and there seems no negligence on the part of jail authorities or presence of any abnormal circumstances for the death of deceased Purnachandra Behera. This is and in addition to it, we also requested the Honorable Single Judge that there is an inquiry going on by the National Human Rights Commission, and he is also awaiting for this report. So no judgment will, no final order be passed. And the Honorable Single Judge, and in fact, this report came after the judgment of the Honorable Single Judge. And this is the clear finding of the SDJM after examination of 10 witnesses. The magistrate has examined 10 witnesses and the 4 documents, and ultimately came to such a conclusion that there is no negligence on the, it is a clear hanging case due to asphyxia, the person died. So when there is no abnormal death, when there is no fault on the part of the jail authority, so compensation cannot be awarded. And the Honorable Single Judge erred in law by passing the impugned order without awaiting the report of the magistrate, which is mandatory and which is according to the section 126(a) of the, which is prescribed under section 176(1)(a) of the CRPC. And this is the main ground which we have raised in the appeal memo. And this is a subsequent event. After the judgment, we have received the magistrate report. In fact, your lordship will appreciate counter affidavit was also not filed, 7 except certain documents and judgments of this honorable court, wherein the necessity of that magisterial report is also emphasized. And the Honorable Single Judge has disposed of the matter by saying that the division bench order of this honorable court is not applicable and it is distinguishable. That is a different matter. But so far as the magisterial report is concerned, which is annexed as Annexure 8 to the writ appeal, there is a clear-cut finding that there is no negligence on the part of the jail authority. And in view of that, the jail authority cannot be awarded with any cost or compensation cannot be paid by us. That is the main ground in the appeal. The delay is 11 days.
But how did he die? They found him.
That is the finding of the magistrate.
No. Just was he hanging in the cell or not? How was he found?
Hanging as a result of hanging, and that seems no negligence on the part. This is the finding. I'm just placing the finding because this is.
How was he found? How was the deceased found?
Yes, that I have detailed in the appeal memo. Your Lordship may kindly see the facts of the case. Yes, paragraph 3 of the appeal memo, page 7. That the deceased Purnachandra Behera UTP number so-and-so was admitted to subject Kendrapada on so-and-so in connection with such and such. On 1st January 2021, at about 9:30 p.m., when the jail warden was visiting all the wards near ward number 5, one of the inmates informed him that the deceased fell down on the ground when he had been to the toilet. He then went to the spot and saw the deceased lying near the door and other inmates giving water to him. Then the superintendent of jail substituted the deceased to Purnachandra Behera to so-and-so DHS Kendrapada, but unfortunately, doctor declared him dead. An unnatural death case was registered in presence of the executive magistrate. So-and-so copy of the inquest report is there. Since it was a case of custodial death, the body of the deceased was sent for the postmortem, and the cause of death is due to combined efforts of asphyxia and venous congestion as a result of hanging. However, the final opinion as cause of death reserved pending chemical.
Where did hanging come in? Nobody saw him hanging. Where is the statement that somebody saw him hanging?
That the learned magistrate has discussed the evidence of 10 witnesses.
Where is that?
Yes, that.
But the entire report misses this whole essential point.
But there is a positive finding that there is no torture on the part of the.
No, that's not
That
enough.
hanging word, your Lordship, is there.
Where did whatever he said in the report, it's only that some inmate found him lying on the road.
Yes, ma'am.
Lying on the floor.
That is correct, your Lordship.
And he's told that he fell in the toilet.
As a result of hanging, this hanging part is not
explained properly.
I'll take instruction from the appellant as to how this.
Why don't you deposit 10 lakhs in the court, please? Let it be in an interest-bearing account.
Hello, only 1 week time may be granted.
No, but you can still deposit it in court, sir.
I will take instruction as to how this hanging part, only 1 week, next Tuesday. So that if that is not there, because I also find that so far as hanging is concerned, none of the witness have deposed before the executive magistrate, before the magistrate. That it was, they saw when that the deceased was in a hanging position on that particular date or time. That I will get a clarification, and it may be
No, because
listed
the
next.
order is 22nd July. It's more than 8 months ago. And you've not implemented, obviously, no? You see, the state is an appeal against an impugned order dated 20 July 2022, passed by the learned single judge, disposing of writ petition civil 41921 of 2021, filed by the respondent, and directing the state to pay rupees 10 lakhs as compensation for the death of the father of the respondent in jail on January 1, 2021. Paragraph. One of the grounds on which the impugned order is challenged is that just 2 days prior to the said order, an inquiry report was submitted on 20 July 2022 by the SDJM Kendrapada that the death of the deceased, open quotation, might have been caused due to combined effects of asphyxia and venous congestion as a result of hanging, and there seems no negligence on the part of the jail authorities or presence of any abnormal circumstances for the death of deceased Purna Chandra Behera, unquote.
And let me notice such inquiry was conducted in exercise of power under section 176.
The inquiry report was the report was of an inquiry under section 176 bracket 1 capital A bracket CRPC. Paragraph. Interestingly, the report is silent on how the conclusion regarding death due to hanging was reached, particularly when it notes that the witnesses found the victim on the floor, lying on the floor. And the inmates informed that, open quotation, the deceased fell down on the ground when he had been to the toilet, unquote. The postmortem report definitely showed that, open quotation, there is a ligature mark on the neck, unquote. Therefore, the report does not appear to clearly indicate the basis for reaching the conclusion as noted here in the court. Paragraph. At this juncture, Mr. D.K. Mahathi, learned AGA, prays for some more time to produce translated copies of the statements of the witnesses during the inquiry, which perhaps might throw light on the above aspect. Paragraph. With the impugn order having been passed on 22nd July 2022, that is nearly 8 months ago, and with the appellant not having complied with it till date, although there has been no stay of said order, court considers it appropriate to direct that the appellant will deposit in this court a sum of rupees, the said sum of rupees 10 lakhs, and also an additional rupees 10,000 towards the litigation expenses of the respondent. Full stop. Respondent number 1, you say. This be done positively on or before 15th May 2023. The sum of rupees 10 lakhs when deposited will be kept by the registry in a fixed deposit with the nationalized bank, initially for a period of 6 months, and shall be kept renewed during the pendency of the present appeal. Paragraph. The additional documents filed by the appellant will be supported by an affidavit and shall be filed before the next date. List on (16th May).
Item number 20.
Item 20 is relating to multi-purpose health worker. Similar matter, Lordship has kept to 6th of July. I've given a copy. Lordship's order. I've given it.
Item 21.
21 also same, my lord.
Same one.
Item number 22.
A laboratory technician, 13th court. 13th April.
Audit.
Item 23.
23. Let's feed it to 11.5 that I have given this copy. May.
Same one.
Item number 24.
8th August outsource.
10th August. 8th August. Sorry.
Item 25.
13th September.
All right.
Item 26.
26.
26 permitted to withdraw with the liberty to file review.
Item 27.
27, my lord, Lordship has got similar matter to 49.
Right.
Item number 28.
At 25th April.
All right.
Item number 29.
None appears dismissed.
Item number 30.
Lord, our 2930, I undertake to file the original certified copy within a week.
All right. What is the matter about this?
Page 12.
There's nothing in this matter.
The vacancy of the year 2011 and recruitment of the year 2015.
There was an interim order saying his result, he may be allowed to participate in the recruitment process, but the result shall not be declared and kept in the seal cover.
Miller advertisement was in the year 15.
So I applied pursuant to the advertisement. The basic question to be decided here is that the diploma engineering, which has been which is the qualification of the petitioner, and +2 science, whether equal or not. The board has given the certificate that +2 science is equal to diploma in engineering.
Where is it?
I have completed first class. I have got first class.
Where is that clarification? Where
Is
is the
that
clarification that these are equivalent? Where is that clarification, sir? You're not able to hear me.
Yes, but I was not hearing, my lords.
Mind is wandering somewhere. Very difficult, sir. Your case is being heard and your mind is somewhere else.
I'm sorry, I could not.
Where is the clarification that the diploma and result of +2 is equivalent?
My lord. Diploma and +2 science are equal, and the necessary certificate is
page 11. Page 11, my lord.
Annexure 2, page 14.
Where is the advertisement?
Advertisement, next annexure, my lord, page 15. Where it is described in Oriya after about one para, second para, which begins with Sarvanimna Sikhyagata Yogyata, the minimum educational qualification.
What is it? say?
Sukriti Prapta Anushthanaru, intermediate science or +2 science किंबा और उच्च माध्यमिक विज्ञान हायर सेकेंडरी साइंस और इक्विवेलेंट एग्जामिनेशन व्हिच इज इक्वल टू +2 धंधामूलक शिक्षा in animal husbandry.
One minute. So there is an interim order. What's his name? Mr. Das. Mr. Das, there is an interim order.
Yes, madam.
Which says that his result should be kept
in a seal cover. My lord.
So the idea was that it should not become infructuous.
He has also participated. He has taken that away. Yes, madam.
You see, the impugned order appears to be the impugned order passed by the learned single judge dismissing WPC OA 2074 of 2016 reads as under. Reproduce the impugned order at page 12, paragraph. The court notes that the above, that initially the appellant had filed OA number 2074 of 2016 before the Odisha Administrative Tribunal, bracket OAT. And on 22nd September 2016, sorry, it was noted that the appellant had applied for the post of livestock inspector pursuant to an advertisement issued. Give me the date of the advertisement. Where the educational qualification was prescribed as +2 science or equivalent. Full stop. The candidature of the appellant was rejected because he had a +2 diploma. Paragraph. At the next hearing on 23rd November 2016, an interim order was passed by the OAT that since the appellant possessed +2 diploma and was placed in first division, open quotation, he may be allowed to participate in the recruitment process by way of verification of the document, but the result shall not be declared and shall be kept in a seal cover, which will be subject to the result of the OA, unquote. Clearly, the above interim order anticipated the contingency that if the matter was pending for a long time, it may be rendered infructuous, but for such an interim order. Paragraph. In the circumstance, the court is informed that the appellant did appear for the did participate in the recruitment process pursuant to the above interim order, and his result has been kept in a seal cover. Paragraph. In the circumstances, it cannot be said that the appellant's writ petition, which was the very same OA transferred to the High Court after the abolition of the OAT and renumbered, has been rendered infructuous due to passage of time. Paragraph. The impugned order is accordingly set aside, and writ petition civil OA 2074 of 2016 is restored to the file of the learned single judge in the roster bench. Full stop. Since counter affidavit has already been filed by respondent number 3 before the OAT itself, it is directed that the above writ petition will now be listed before the learned single judge in the roster bench on 1st May 2023, by which time, if he so chooses, the appellant writ petitioner can file a rejoinder to the above counter affidavit. The learned single judge is requested to proceed with the hearing of the petition on merits and endeavor to dispose it off as expeditiously as possible. The writ appeal is disposed of in the above terms. The same order for the next one, correct?
Item 30.
30 also similar.
Similar, there the qualification is +2 sides. Similar. Participated, interim order there. Result is sealed cover.
All right.
Item 30.
30. You see, in view of the order passed today by this court allowing writ appeal number 1252 of 2022, the present writ appeal is allowed in the same terms. And
Item
the corresponding
30 is different,
WPC.
I'm sorry, item 30 is different, my lord.
30 is different.
My lord. The counsel may be same, but the issue is different. Lord, should we kindly see page 16. There's a recruitment to the post of livestock inspector.
Yeah, same.
No, Lord, should we for a moment kind to come to page 18, my lord. He was not an eligible candidate. That is the ground on the rejection, my lord.
+2 sides.
Page 18, Lord, should we kindly see to the middle portion. 10 lines from above, my lord. The petitioner is not a Gomitra candidate and his name has not been considered on the ground that he has passed +2 sides. Thereafter, my lord, the vacancy positions have been, my lord, discussed, my lord. 50% of the vacancy shall be filled up from among the candidates who have passed +2 vocation, and remaining 50% shall be filled up from among Gomitra candidates. Para 7, my lord. Since the petitioner,
So if he already got +2 sides, he doesn't need to be Gomitra.
my lord, that is an additional qualification as it seems, my lord. Para 7, Lord,
Essential qualification.
Lord, should we kindly see para
Minimum qualification he is having. And that has been allowed in other cases also by my lords here.
Lord, should we para 7, Lord, should we kindly see, my lord. In view of such position, since petitioner is not a Gomitra candidate and his application has not been considered on the ground that he has passed +2 signs, the claim for publication of result does not arise as the petitioner was allowed to appear in the exam. Lord Shime, yes, I'm sorry. Lord Shime, pass the same. Yes, here also interim order was there.
Interim order set aside. And the corresponding writ petition civil OA number 2075 2016 is restored to the file of the learned single judge, where it will be listed on same thing. Since account has already been filed.
Item number 31.
My lords, this is the impugned judgment is under Annexure 1, my lords. This is basically regarding dispute as to the departure of the vehicles from Bhubaneswar of the petitioner's bus as regards to respondent number 2, my lords. Since both the vehicles of the petitioner and OP number 2 clashes, the timing clashes, so there was a dispute for which the petitioner filed an objection, wherein considering the application, the STA authority has scheduled the time of the respondent number 2 to 1:10 p.m. and that of the petitioner to 2 p.m. my lords. So thereafter, my lords, since that was fixed to 1:10 p.m. 50 minutes ahead of the petitioner's bus, so he made an objection. Considering that the respondent number 2's departure time was rescheduled to 3:45 p.m. That was his original time schedule. So when that was fixed, now the respondent number 3 and 4 was put to difficulty because their timings also coincided with the changed schedule. One was of 3:45 same and one was 3:50. So nearly 5 minutes difference. For which, my lords, considering their objections, respondents 3 and 4, again the respondent numbers 2's time departure was rescheduled to 1:10 p.m. So that again, petitioner, the present appellant, was put to difficulty. So then the appellant again filed an objection revision before the learned tribunal, which learned tribunal did not interfere. Held that since that is the time gap is only 50 minutes between two vehicles, that doesn't matter a lot. But the guidelines have been fixed by the Honorable Court in the Sushil Kumar Panigray case, wherein the Honorable Single Judge, while disposing of, my lords, has relied upon this decision, but only on the basis of one of the parameters only has disposed of the case without interfering. Because, my lords, I am the senior operator in that single route. That is a single route operating from Bhubaneswar. So, my lords, when the respondent number 2's vehicle has been fixed to 13:10, that is 1:10 p.m., 50 minutes ahead of my departure time, that is 2 p.m. So, I am put to very much difficult. My business is hampered.
Gap, sir.
My lords, 50 minutes gap, my lords.
50.
My lord. But my lords, if I may also refer the judgment which the Honorable Single Judge relied upon, para 4, if my lords may kindly refer to, I am just submitting the judgment, my lords.
Yeah.
Lord, there several guidelines have been fixed. Paragraph 9, page 3 of the judgment, there 6 guidelines have been fixed for considering the allotment of time chart, wherein the Honorable Single Judge has only relied upon the guideline that parameter 5 of the guidelines. That since it is within 50 minutes, so it doesn't matter a lot. But para 4 also states that the principle that the prior permit holder should have priority over latter permit holders is to be normally followed. That has been ignored, my lords. That is affecting the business of the appellant, my lord.
Or the challenge the present petition is to an order dated 23rd August 2022, passed by the Learned Single Judge, dismissing the appellant's writ petition civil 1105/2021, whereby he had challenged an order dated 4th March 2022, passed by the State Transport Appellate Tribunal, (STAT), Orissa, in MB revision number 13 of 2019. Stop. The STAT in the said order modified the timing allotted to respondent 2 by order dated 31st August 2019 in MB case number 65 2019, and set aside an order dated 15th November 2019 passed by the Secretary STA. Full stop. The STAT allowed opposite party, respondent 2 to ply his vehicle on the route from Gandhisa to Cuttack with departure time at 13:10 hours from Bhubaneswar. Paragraph. Consequently, the appellant is agreed by the said order on the ground that his time of time of departure of his buses at 1:20.
1:10.
No, the other side is
Other
1:10.
side is 1:10. Mine is 2 p.m.
Is at 2 p.m., which is very close to the time of departure of the bus of respondent number 2, and therefore it would adversely affect his business. Full stop. The court is unable to accept the said plea and respectfully the said plea. Full stop. The view expressed by the learned single judge that a time gap of 50 minutes between the vehicles departing from Bhubaneswar, open quotation, cannot be said to be a little gap, unquote. Relying on Sushil Kumar Panigrahi versus Commissioner cum Chairman, State Transport Authority, 89, 2000, CLT 788. It was held that the interval in the time of departure of the two buses would depend on the total volume of passengers available. And normally, a 25 to 30-minute gap should be considered reasonable. Paragraph. Having heard learned counsel the appellant and having perused the impugned order of the learned single judge, in light of the judgment decision referred to, court is unable to be persuaded that any error has been committed by the learned single judge in dismissing the appellant's writ petition. Full stop. There is no merit in the present appeal. It is accordingly dismissed.
Item 32.
May I please your lordships? In this matter, the appellant is challenging the order of the Honorable Single Judge at Annexure 1, my lords. My lords, the matter relates to stopping of unauthorized construction at the instance of petitioner by the local police at the instance of the respondent number 3, my lords, without affording opportunity of hearing, my lords. My lords, so lordship may kindly have a glance at Annexure 6. My lords, the notice was issued to the local IIC.
Yes.
The notice under Annexure 6, my lord, page 32, was issued to the local IIC to come to the disputed property and stop my construction carried out by me, my lords. My lords, the Lord Jagannath Temple Managing Committee, my lords, they have made this requested the HDPO to make such direction to the local police to go and stop the construction, my lords. But earlier, my lords, they have the employees of our respondent number 3 had come and threatened the petitioners for eviction, for which the petitioner had approached this honorable court. And they are the learned counsel for the respondent 3 appeared and said that these allegations are unfounded. And basing on that, the writ petition was disposed of. Only after the disposal of that writ petition, this fresh notice was issued to the local IIC to stop the unauthorized construction, my lords. My lords, under the Jagannath Temple Act, my lords itself, under 16A, it is there the opportunity of hearing is to be provided in case of removal of unauthorized possession, my lords. But bypassing all those provisions, they have directed the local police to go and stop the construction, my lords.
Who are you for?
Pardon, my lords?
You are what? What is your local standing?
My lords, your fact of the case, my lords, earlier the disputed property was recorded in the Dakshina Parswa Matha, my lords. And after the Siddha Matha judgment, the land was, and I am a subtenant under the Dakshina Parswa Matha, my lords. After the Siddha Matha judgment, the land was settled in the name of Lord Jagannath, my lords. So my entry into the possession of the property was disputed for the permissive. After the passing of the Siddha Matha judgment, they are saying that it is unauthorized possession, my lord.
Correct.
And basing upon that, my lords, Jagannath Temple Act 16A provides that in case of unauthorized possession, action has to be taken in terms of provisions of OPL Act, my lords. There is provision for granting opportunity of hearing to the appellant, my lords. But bypassing all those provisions, they have directed the police to go and stop the construction.
The point is that you are encroaching on the temple's land.
No, my lords. I am in possession since 1992, my lords.
Right.
And if it in the meantime it has become unauthorized, I may be given. I'm only a prayer is my lord. Only opportunity of hearing may be given if before any action is taken against me.
No, but the facts are not in dispute. Where's the question of hearing then?
Well, sir, your lordship may kindly have a glance at section 16A, my lord. The act itself provides to provide opportunity of hearing to me. And in the counter affidavit, they have admitted that my status is that of a subtenant, my lord. And in terms of for subtenant, the OL
come to para 6, page 31.
My lords. My lords. My lords, taking into consideration the submissions of the learned counsel for the parties, this court finds that no notice as required under law is issued to the petitioner for his eviction for the case land. There is no material on record to show that petitioner was threatened of eviction. As such, my lord, this was the earlier order, my lord. This is not the impugned order. In the impugned order is under Annexure 1, my lord. In the earlier order, they said that there is no, my allegation was unfounded. Nobody is threatening to me for eviction, my lords. But after the disposal of in the light that the allegation is unfounded, they have issued this notice under Annexure 6, my lords, to the local police, my lords. My only prayer is, my lord,
here again come to para 6, page 18.
My lords.
6 and 7.
My lords. Shall I place it, my lord? Taking into consideration the submissions made by learned counsel for the parties, it is apparent that the case land stands recorded in the name of Sri Jagannath Temple Managing Committee. The petitioners claim to be in possession of the case over the case land, which is seriously disputed by the authorities of Sri Jagannath Temple administration. However, it is submitted by Mr. Mahapatra, learned counsel for the petitioners, that the petitioner number 1 had a chicken shop over the case land, which was destroyed during cyclone of Fani, and she had instructed the petitioner number 2 to renovate and repair the said chicken farm or shop. There is no material on record to show that there was in fact a chicken farm over the case land constructed by the petitioner number 1. It is also not clear that in what capacity such a farm is being attempted to be constructed over the case land by the petitioner number 1. In order to make any construction over the case land, the petitioners have to take permission from the true owner, namely Sri Jagannath Temple Managing Committee, Puri. No such permission is apparently taken from the true owner to make such construction. It also appears from the counter affidavit that the authorities of Sri Jagannath Temple administration have requested the Tahsildar Nemapada to take steps for eviction unauthorized occupant, namely the petitioner number 2 from the case land, by initiating proceeding under section 16A of the Act read with provisions of the OPLE Act, my lords. When an unauthorized construction is being attempted to be made over the case land, the true owner, namely Sri Jagannath Temple administration, has to take steps to protect their land. Thus, the authorities of the Sri Jagannath Temple administration have requested the superintendent of police to instruct the IAC Balanga PS to stop construction of the case land. As such, I found. My lords, your lordship may kindly have glanced at paragraph 6, my lord. When they have already initiated a proceeding under section 16.
You are not in possession, sir.
My lords, I am in
to prove that you are in possession or that you are raised.
My lords, your lordship may kindly have glanced at the rent receipts, my lords.
No. This all can't be gone into the writ petition, sir.
My lords, that is what I am saying, that since a proceeding has been initiated and there is scope for...
went to the court. You went to the court and you wanted relief. You have got this finding.
My lords,
that you are not in possession.
My lords, I am in possession, my lords. But that is what
that can disputed. You have not produced a scrap of paper to show you are in possession.
My lords, your lordship, I have also annexed the photographs, my lords, to show that I have constructed a chicken shed over it.
Yeah.
And see, if I am not in possession, how are they moving to remove my encroachment? If I have not encroached, my lords, that is the only question, my lords. And my only submission, if they have already initiated a proceeding under 16A, these disputed facts can be established in that proceeding, my lord. Yes. Because 16A does not only provides that I shall be evicted. If it is shown that I am in possession for a considerable time, then it can also be settled in my name, my lord.
Yes.
That is there. And regarding that, I want to rely on a decision of the Honorable Supreme Court, my lords, because these possessions cannot be considered as trespass, my lords. Lordship may kindly have glanced at it.
There is no chance of any settlement so far as the Jagannath Temple land is concerned.
After Siddhamath, nothing can
happen. After Siddhamatha, he admits that in terms of Siddhamatha, this suit land belongs to Jagannath.
Yes, ma'am.
Even if he is encroacher, already eviction.
My lords, after Siddhamatha,
So Olga Telis, not please don't.
My lords,
These are all-
Olga Telis, my lords,
Completely different context.
my lords,
Olga Telis, they were pavement dwellers.
my lords.
But
in
you're not a pavement dweller.
paragraph 47, my lords, the
Yes,
Honorable
yes.
Court has decided that it is not a case of criminal trespass.
All right.
And even in case of trespass, opportunity of hearing has to be granted, my lords.
You have enough, sir. You've been heard by the single judge. You're not being able to produce a scrap of paper.
My lords, that is what means, since here it is not scope, there is no scope for appreciation of evidence in the writ petition. In
fact,
16,
in writ petition, there should be
in
no
the
such
proceeding under the Appeal Act, there is the scope for appreciation of evidence, my lords.
You went to the writ petition, sir. You should have gone for some.
Well,
other
since they are directing the police to take
so even you can get an injunction in a civil suit.
Well, that is the one. Since under Jagannath Temple,
So you went before the writ court. You never availed of the other remedy. Now that you've lost in the writ court, you say I should have gone to the other remedy.
No, my lord. See, they are to initiate a proceeding, and they have rightly initiated a proceeding. I am not disputing that, my lord. And regarding civil suit, my lords, there is a bar under the Sri Jagannath Temple Act to move to the civil court against the action of the officials of the Sri Jagannath Temple Managing Committee.
The challenge the present writ appeal is to an order dated 24th August 2022 passed by the learned single judge dismissing the appellant's writ petition civil 399008 of 2021, in which writ petition the appellant had sought a direction to quash a notice dated 5th November 2021 issued by the Superintendent of Police Puri to the OIC Balanga PS requesting him to stop unauthorized construction or land belonging to the Sri Jagannath Temple administration on the allegation that the present appellant that one Akrura Senapati was raising unauthorized construction of chicken farm over an area of AC 0.22 decimal under the Halkata number 8 of the said Moza. Paragraph. Apparently, appellant number 1 claims to be a Bhag tenant under the erstwhile endowment board, paying rent to the landlord and enclose certain rent receipts. Full stop. Akrura Senapati, appellant number 2, stated to be working under appellant number 1 and looking after the chicken farm constructed over the state over the state land. Full stop. Contending that the land stands recorded in the name of Sri Jagannath Temple Managing Committee, and therefore the police authorities have no locus standi to issue the imbue notice. The appellant sought the quashing of the said notice and to permit Akrura Senapati, open quotation, to make construction of chicken farm over the case land. Unquote. The above writ petition was the second round of litigation. Full stop. In the first round, writ petition civil 16273 of 2021 was filed, resisting possession from the disputed land without following the procedure established by law. Full stop. That writ petition was disposed of by the learned single judge by an order dated 11th August 2021. Noting that after the judgment of the Supreme Court of India in Sri Jagannath Temple Managing Committee versus Siddhamat 2016 1 OLR bracket SC 209, the case land already stood recorded in the name of the temple administration. Full stop. However, the learned single judge found that with no notice having been issued to the appellant for his eviction from the case, or material to show that he was being threatened with eviction, the apprehensions expressed by the appellant were baseless, and accordingly the writ petition was dismissed. Paragraph. As far as the impugned order is concerned, here too the learned single judge notes that the appellant's claim to be in possession of the case land was seriously disputed by the Sri Jagannath Temple administration. Full stop. There was no material to show that there was, in fact, a chicken farm over the case line which had been constructed by appellant number 1. Also, no permission appeared to have been taken from the Sri Jagannath Temple Managing Committee for raising any construction. So, in the above circumstances, the learned single judge declined to interfere. Paragraph. Having heard learned counsel for the appellant and having examined carefully the impugned orders, the impugned judgment of the learned single judge in light of the other documents on record, the court is not persuaded that the learned single judge has committed any error which warrants interference. Full stop. The burden was on the appellant who had filed the writ petition to substantiate his contention that he was in lawful possession of the land in question. Full stop. This itself appears to have been a disputed question of fact, which could not have possibly been examined in the writ petition. Full stop. The action taken against the appellant was obviously under section 16 capital A bracket 1 of the Sri Jagannath Temple Act and with the provisions of the OPLA Act, and therefore the appellants cannot be heard to say that notwithstanding they're lacking any authorization whatsoever, they should not be evicted from the suit land. Paragraph. Learned counsel for the appellant relied on the decision in Olga Tellis versus Bombay Municipal Corporation, AIR 1986-180, to urge that the principles of natural justice have to be adhered to for evicting the appellants. Paragraph. The appellants have received enough notices and were in fact in a position to assail them before the single judge where they were fully heard on merits. So consequently, the court finds no applicability of the ratio in the above decision of the Supreme Court. Paragraph. The court finds no grounds made out for interference with the impugned order of the single judge. The writ appeal is accordingly dismissed.
My lords, even after the Siddhartha judgment, my lords, the Honorable Supreme Court said that they may carry out the execution in terms of Code of Civil Procedure and Constitution of India. Neither of them provide for action taken by local police, my lords.
Item 33. Item 33, my lord, rehabilitation assistant, my lord. 38.
Yeah, 30 August.
Item 34. 34, my lord, work charge employees, my lord, 14.9.
14.9.
Item 35.
35, I pray for an adjournment on behalf of Alok Prasad Nanda. It's out of session.
What's the matter about, sir? Open your paper book. Tell us what the matter is about. Open your paper book, sir. Tell us what the matter is about.
My lord, yes. My lord, yes.
Come to page 35 of the paper book. Come.
My lord, he has instructed me.
Sir, please open the paper book. Come to page 36.
I don't have the file. Don't have the file.
Where's such a pathetic state, sir? You're appearing before a high court without a scrap of paper, not knowing what the case is about. We only can pity you.
CMAPL was dismissed on the ground of delay, 1,000 more days.
The impugned order dismisses an application for recall of an order dated 6 September 2019 by which CMP number 741 of 2018 was dismissed for default. Additionally, there was a delay of 1018 days in filing the CMAPL. Paragraph, the learned single judge has found that the peremptory order had been passed on 26 August 2019, requiring the appellant to file requisites for issuance of notice to the opposite party number 3 in the CMP. Stop. The appellant did not comply with that notice, and therefore the CMP was dismissed on 26th August, on 6 September 2019. Full stop. There was no satisfactory explanation for the inordinate delay in preferring the application for recall of that order. Paragraph. The court is unable to find any error having been committed with the learned single judge in the impugned order. The writ appeal is dismissed.
From 36.
You may please your lordship. In this case, this writ appeal arising out of a proceeding under the provisions of Odisha Consolidation Act. Originally, the petitioner approached the original authority before the consolidation officer to record his land in his favor under Annex 2, page 21, the original authority's order. On the basis of a sale deed where of the year 1955, where he has purchased, his vendor has purchased the plot number 84-2 and area 13 decimal, and thereafter he has purchased in the year 81. The original authority, the opposite party objectors appeared and contested the case. Both the parties declined to adduce any oral evidence before the original authority at page 22 that has been reflected, had both parties on series of dates and went through the documents and written notes of argument filed by both the parties. Both the parties have declined for oral evidence and relied on documents. And where the original authority recorded the submission of the parties, that has been at place 24, the petitioner's submission. I am placing since the fact of the case is required.
So remanded, sir. Sorry.
No, that remand has been made by setting aside the concurrent finding of the original authority, as well as the appellate authority, as well as the revisional authority.
Right.
And the remand made taking the plea that the shortage of the extent of the land. Yes. That is not the dispute before the original authority.
Right.
What was the dispute before the original authority and the appellate authority? The opposite party claimed that in the sale deed of the year 1955, plot number 5343 has been executed in his favor, but that is not the correct plot number. Correct plot number is 84-2, which requires oral evidence, and this is a patent ambiguity. And that cannot be taken away. No evidence can be adduced in view of section 93 and 94 of the Indian Evidence Act. That has the non single did not take note of the dispute between the parties on what score the objection of the writ petitioner has been turned down by 3 authorities. All the authorities has been examined the records of the parties and found that the consultation authority lacks jurisdiction to treat the oral evidence, treat any other evidence to constitute the plot number 5343 is in place of 842. That is the finding of the authority. I am placing my note. I want to place my note. The learned single judge proceeded as if the parties, the objector claiming the plot number is correct,
the extent of land is not available in such plot. Therefore, the boundary will prevail, and on the basis of boundary, it can be re-adjudicated. But the entire case of both the parties are totally different. That is why I want to place your lordship. The original authority order at place 31 million. The above discussion will, I am pressing. The above discussion will show that Sabik tenant Gopal has sold plot number 84 to area 19 decimal to his other 5 brothers, and his brothers, on the other hand, said Gopal plot number 5343, page 31 million. 5343 part 24 decimal. There are no necessity to execution of both the deeds since all the 6 brothers were equally entitled both plots. So execution of the above deed clearly shows that there is a mutual partition among them, and accordingly they have executed the respective plots only for exchange. Now even if opposite party take a plea that plot number 5343 is wrongly reflected for plot number 842 on the sale deed, this does not appear a sound argument. However, the suit sale deed is not cancelled in the proper court of law, and opposite parties have not taken no steps to rectify this defect. The opposite party's claim stands no merit. And this is the issue again gone to the appellate court. In the appellate court, nowhere that there is any discussion that because of shortage of the land in plot number 84.2, the objector could not record their land, or the recording of the land in favor of the present petitioner is erroneous. So the issue, the dispute between the parties is that whether the plot sold in plot number 84.2 sold in the sale deed executed in my vendor's favor, or plot number sale deed executed in favor of the opposite party. And there is no question of any boundary dispute between 3 authorities. Now the single judge has gone to the extent saying that the boundary will prevail and boundary will solve the
boundary is only an indication, he says. Merely because the exact description is given does not mean that you can ignore the sale deed. No. Sale deed still gives the outline of the boundary. You can make further inquiries to find out who gets what share. That's what he's saying.
If the issue was before the both 3 authorities that the boundary description has to be taken into consideration, then they might have different. Before all the 3 authorities, the dispute was raised that a wrong plot has been indicated in my sale deed, and it needs further evidence which beyond the recitals of the deed is clear and ambiguous. There is no ambiguity. And the plea advanced by the objector is a patent ambiguity. And at a too late after 65 years, my lord. And this, after 65 years, such direction for remand is unjustifiable, my lord. That is the unreasonable, my lord. My submission is that the point of law involved in this, when the consultation authority under the OCSI People Act are not empowered to rectify the defects available in the sale deed. Now, by virtue of this order of the Honorable Single Judge, the defect in the sale deed after 65 years is going to be rectified without approaching the competent court of law under specific relief act.
All right. You see the impugned order dated 26 August 2022, passed by the Single Judge, disposing of writ petition civil 3618 of 2003, filed by opposite parties 1 and 2, respondents 1 and 2, has, while setting aside the orders challenged therein, remanded the matter to the consolidation officer for considering the matter afresh after taking note of the recitals in the sale deed. Sale deeds produced by the parties. Full stop. Further, the remand itself has been made time-bound. Paragraph. It must be over by now, this remand.
No, my lord. No, that has not been completed. A specific instruction I have received, that has not been completed.
Paragraph. Having heard learned counsel for the appellant and having examined the impugned order in light of the documents placed on record, the court is not persuaded that there is any serious error in the impugned order that calls for interference. Full stop. The learned single judge has noted that the sale deeds produced have been overlooked only because the extent of land sold were not disclosed therein, although the boundaries of the land sold were described. Full stop. Although counsel, the appellant contended that the proper remedy was to only approach the civil court for determining these complicated questions, it will be open to the parties to produce before the consolidation officer whatever material is available in their possession to substantiate their respective claims, which will then be examined in accordance with law by the consolidation officer. Full stop. If the proceedings have not yet been concluded, then in terms of the impugned order of the learned single judge, the said proceedings before the consolidation officer will stand concluded within a period of 4 months from today. A copy of this order be sent to the consolidation officer. Where is he?
Let consultation officer Puri Banda.
Puri.
Consultation officer Gopo Kakatpur Puri.
Gopo?
Gopo.
Gopa.
Well, I may be
Puri forthwith for compliance.
Well, I may be permitted to lead evidence since the original author.
Yes, sir.
Well,
all right.
Well, one line, otherwise
nothing will happen, sir. All right.
Otherwise, the initial order both proceeded without leading evidence. Now, when the face remand has been gone, then that is required to be made.
All right. All right.
Item 37.
37, my lord, pray for 1 week time for defect to remove defect, my lord.
What's the matter about? What is the case about?
Pass over, my lord, after lunch.
All right, pass over.
38.
38, rehabilitation assistant, 38.
Right, 30th August.
Item 39.
Work charge employee, 14.9, my lord.
Right.
Item number 40.
None appears dismissed.
Item 41.
My lord, rehabilitation assistant, 38, my lord.
10th August.
Item 42.
There is a delay of 11 days.
That's
Delay may be confirmed and the matter may kindly be posted to some other date. Mr. Mantri has some personal difficulties. He has requested for an adjournment.
What's the matter about? Let's see.
Lord, it involves multiple facts involving the claim of a petitioner in a sealing proceeding has been turned down. And that number of annexures that has been turned down by the revenue authorities. My lord, Mr. Mantri will place the matter.
Just look at this. Who's for the opposite parties?
This copy is not served on us. That is what also I was 42 items. Copy ta dele gote. Oh, this one. Ah, yes.
The present appeal is directed against an order dated 29 September 2022, passed by the learned single judge and dismissing the writ petition civil 15249 of 2005, whereby the present appellates had questioned an order dated 24th October 2005, passed by the collector Kalandi. Dismissing OLA revision case numbers 4 and 5 of 2004, which in turn questioned the orders dated 13/2/2004 of the Tahsildar Dharamgarh, as well as the appellate order dated 13th February 2004 of the sub-collector Dharamgarh. It is seen that in the writ petition pending since 2005, notice had been issued
Each case is that there was a earlier OLR case by number 15/74.
Correct.
And the Honorable Single Judge, you failed to provide the material to show that that case was dropped.
Yeah, 24th January 2006. And there was also an interim order in favor of the writ petitioners. Paragraph. Without examining the contention of the appellants, a cryptic one paragraph order has been passed by the learned single judge which reads as under. Reproduce the whole order. Paragraph. This was not a matter which would have been dismissed on account of open quotation, sufficient loss of time, unquote, when there is an interim order in favor of the writ petitioner, when there was an interim order in favor of the writ petitioner, which was continuing for almost 16 years. Full stop. The merits of the matter had to be examined, and the writ petition could not have been rejected in a summary manner without discussing the contentions raised by the appellant writ petitioners. In these circumstances, the court is constrained to set aside the impugned order and restore writ petition civil 15249 of 2005 to the file of the learned single judge, where it's been listed for hearing on 16th May 2023. Since the court does not find any reply having been filed to the said writ petition, not 15th May, it's the 10th July. 10th July. Since the court is unable to find any counter affidavit having been filed by the state in the said writ petition, it is directed that such para-based reply to the writ petition will be filed by the state not later than 3rd July, and the rejoinder thereto finish will be filed by 10 July. No further time will be granted for that purpose. The interim order, which was inuring in the writ petition, would continue till the disposal of the writ petition on merits by the learned single judge in the roster bench. Considering that it is a writ petition of 2005, the learned single judge is requested to dispose of the writ petition on merits as expeditiously as possible. The writ appeal is disposed of in the above terms.
Item 43.
Item number 40. But I am sorry, my lord, that when I call, I could not hear. Item number 40, I am sorry because I could not hear when it was called.
40.
I thought there is a mic here.
Mic is clear, but
I think we should blame him.
Mic is.
Yes.
We use a mic, you don't use a mic. We are able to hear you even without a mic. You are not able to hear us with the mic. It's a good combination. Very good combination. So maybe we should switch off the mic, then you will hear it clearly. All right. Tell us.
My lord, this is an appeal. What happened in this case, my lord? The petitioner is retired in 2015. Thereafter, no pension, no gratuity was given to him. He filed an application before the State Administrative Tribunal in the year 2019. And after receipt of the notice, they paid the pension. But the gratuity, though decided, has not been paid. Then, when the matter was transferred to this honorable court, the honorable court disposed of it on 11/10/22 by only saying that to pay the gratuity. My specific prayer was from the beginning to pay the interest because there is delay without any fault on my part.
Plea for interest also. You've been permitted to move the accountant general.
No, I raised the interest from the
gratuity entitlement means with interest only. Entitlement, the word entitlement.
Because statutorily I am entitled.
Yeah, whatever you're
but my lord, my whole predicament, even after passing of this honorable court order, like this honorable court, the honorable single judge, till that they have not paid the gratuity to me.
That you file contempt, sir.
Now, I will file the contempt, but the question of interest, the learned single judge has not yet decided whether I will get it or not.
Entitlement means you claim that interest. Have you moved the accountant general? In para 4 of the impugned order, come to page 24.
No, para 4, this para 4 has, I have moved. That.
When did you move, sir?
But now.
Just answer the question, sir. When did you move?
I have moved that.
When did you move?
I have moved. My lord, move on. That is on itself in November 2022, and thereafter on my that document is not with me.
Document.
But that document. But thereafter, my lord, what happened? The accountant general.
1 minute. Don't tell us orally, and we don't want to accept orally. First of all, show us the document whereby you moved the accountant general.
My lord, apart from that also, my specific submission.
Sir, if you don't want to answer the questions, we are not bound to answer hear all your arguments.
Well, that document is not with me. Once I have that is not with me. That I can produce it. That is not
for non-compliance with the order. You can go to the contempt.
That I can produce. But
the grievance of the
copy of the document is not with me now.
Against impugned order.
Only 2 days time may be given. I will produce that.
Appears to be that the learned single judge has used the word single quotes gratuity entitlement without specifically dealing with the appellant's claim for interest on gratuity. It is clarified that the word single quotes entitlement unquote would obviously include the entitlement of the appellant to interest, if any, in accordance with law. Full stop. The appellant has already been permitted to move the accountant general for that purpose in the impugned order. Full stop. Paragraph. It is then contended that despite moving the accountant general, the appellant has still not been paid his gratuity and interest. The remedy for non-compliance with the impugned order of the learned single judge lies in other appropriate proceedings and not in the present writ appeal. The writ appeal is accordingly disposed of with the above observations.
Item 46.
46 in similar matter, notice has been issued and posted to 12th July.
Similar to WA number 1457 of 2022.
All right. Same.
Item 47.
May I please your lordship? Lordship, this matter may be pass over, my lord. Mr. Ratho will argue.
Item 48.
My lord, in this matter, Honorable, in this appeal, petitioner, appellant challenged the impugned order passed by the Honorable Single Judge by the Annexer 4, my lord, dated 28th October 2022. Herein, appellant applied for the mutual transfer and submitted the application before the competent authority. Authority, without taking into the consideration of the guideline, rejected the transfer proposal. Thereafter, petitioner filed a WPC before the Honorable Court, and Honorable Single Judge disallowed the petition and rejected the claim. In the similar matter, my lord, another bench of this Honorable High Court at Annexer 5, my lord, allowed the petition.
Yes.
My lord, both the teachers are having close to city qualification. All are in similar category as per the provision 2H of the 2I of the resolution dated 4th October 2018 at Annexer 2, my lord, at page 12.
I don't understand, sir. You are agreed by which order? Which is the impugned order?
My lord, Annexer 4,
page
26, my lord.
Operating portion, page 29.
Page 30, my lord. There is no dispute regarding the fact that petitioner continuing as assistant teacher regular and seek the mutual transfer against the assistant teacher regular. But the fact remains such transfer can only be made if possess the same qualification. The upper quoted clause clearly specify that transfer can be made persons having graduate with science graduate, arts graduate with arts graduate, and commerce graduate with commerce graduate, plus two science with plus two science, plus two arts with plus two arts commerce.
Anyway, so you
my lord, both
you have plus two science, the other person has plus three science.
Yes.
My lord, both are the plus two science and they are
no, it's plus three science.
My lord, at page 11, my lord, 10 and 11, I submitted the online transfer proposal wherein it is categorically stated plus two city science and another is also plus two city science at page 10 and 11.
Then you file a review petition, sir.
But
you file a review petition, yes. Then it's an error apparent in the face of the record. You file a review petition.
Yes, sir.
It's a liberty, my lord.
Counsel for the appellant seeks leave to withdraw the present petition with liberty. Appellant appeal with the liberty to file a review petition in accordance with law. Disposed of is withdrawn with liberty.
My lord, 49 and 50, my lord, similar. Like.
And 48, 49 and 50. Item number 51.
51 and 52, lordship, kindly list this matter on 2nd of May, along with the rate of bill number 1434 of 2022 and 1510 of 2022. The similar matters.
All right. 2nd May.
Item 53.
Obliged.
53 is my lord, lordship posted to 49, my lord. The work charge employees.
49.
53 and 54, my lord.
All right.
Item 55.
May I please, ma'am?
My lord, here for 54 days delay, my lord. Matter relates to pensionary benefit, my lord. In this writ appeal, my lord, the appellant has challenged the
what is the delay?
order of Honorable Single Judge at Annexure 4, my lord.
Yes.
My lord. Here, my lord, the petitioner, while working as a reader in economics, my lord, he was retired on 31st January 2015. And my lord, when his pensionary benefits were not disbursed, he obtained under RTI Act, where he came to know, my lord, that that is at page 43, my lord. It was informed to him that there is a vigilance PS case number 47 dated 36/2012 is pending for investigation, my lord. That is why the pensioner benefits has not been finalized. Page 44, page 44 is the letter of the Director of Vigilance, my lord, wherein they mentioned that the case is pending in investigation. That is the letter dated 18/6/2016. And on the day, my lord, the petitioner is a lecturer, reader, and he is governed in aided college. He is governed under the Orissa aided educational instructions employees retirement benefits rule 1981. That rule I have annexed, my lord, and in that rule there is no provision for any non-denial of pensionary benefits because of the pendency of the vigilance case or any other case or a departmental proceeding, my lord. So, my lord, based on the argument, my lord, they utilize the OCS CCS pension rule, which is not applicable to my case, my lord. The Honorable Single Judge dismissed the writ petition that on the day of retirement, a proceeding vigilance case is pending, my lord. And on the day of the retirement, no charge sheet, no cognizance, nothing, my lord. And no departmental proceeding was pending against me.
No, they say there is an instruction of 21st March 1983.
My lord, that instruction is at annexure. I have annexed, my lord, annexure 6, page 86, my lord. In that instruction, my lord, the Honorable Single Judge raised the clause 18, page 98. May I place, my lord? Clause 18, my lord. And these instructions, my lord, was issued under 4 categories, A, B, C, D, my lord. And it is D category, my lord, that is at page 95.
Yes.
This is payment of death cum retirement gratuity when an employee is eligible to get the same dies while in service, my lord. So to that effect, my lord, rule 18 says, my lord, that is page 98, for items not specifically provided in the instructions. In these instructions, the provision outlined in OCS Pension Rules 1977, so far as the same are not inconsistent with the provisions of Orissa Aided Educational Institution Employees Retirement Benefits Rules shall be applicable. 1977 rule was, my lord, that was repealed since 1992. Consequent upon the introduction of the new rule, OCS Pension Rule 1992, my lord, 1977 rule was repealed. Thereafter, no expressive order was issued the application of the 1992 rule.
That's obviously understood, sir.
And my lord, this para 18, my lord, that is not applicable to my case, my lord, because this has been issued for your lordship kindly page 78. The instruction was issued.
No. This 18 is outside of D, sir. 18 is a general rule.
Yes. No, my lord, this 18 is, my lord, 18 is applicable for the sake of argument. 18 is applicable, my lord. The Honorable Single Judge applied the rule 66(1) of the OCS Pension Rule 1992, my lord. It cannot be utilized in isolation, ignoring the rule 7. Rule 7, my lord, stated that a criminal proceeding is said to have been initiated only when charge sheet is issued and cognizance is taken. In this case, my lord, no charge sheet has been filed on the day of my retirement. No cognizance has been taken on the day of my retirement. And the charge sheet they admitted, my lord, that was issued in the year 2018.
Anyway, charge sheet has been issued.
In the year after my retirement, March after my retirement.
It's all right. Now
and my lord, the settled position, my lord, of this honorable court, my lord,
If your lordship permit me. Your my lord, the Honorable Division Bench, my lord, in the matter relating to the SAT, my lord, Honorable SAT directed that to release the pensionary benefits, since no proceeding, no charge sheet is filed on the day of retirement, my lord. In view of the rule, my lord, I am entitled to get the retirement benefit for the very next day of my retirement. Since the charge sheet is issued much after my retirement, 3 years after my retirement.
3 years. You retired in 2015.
I was retired on 2015. Charge sheet they stated the file
2018.
18, my lord.
17.
And that is contrary to the
17,
rule,
is
my
it?
lord.
17, madam.
That is contrary to the rule, my lord. Rule 7 of OCS pension rule, my lord. Explanation says, my lord, if your lordship permit.
You're only not paid full pension. You're given provisional pension.
Yes, I'm only getting provisional pension, my lord, and other retirement benefits, my lord, because I'm not guided by the aided education rule, my lord.
All right.
Rule 7, my lord, 7(2), sub rule 2, my lord, explanation B1, my lord. Judicial proceedings shall be deemed to be in the case of criminal proceeding in the date on which the complainant or report of the police officer of which the magistrate takes cognizance is made, my lord. Here, my lord, the cognizance has taken, the charge sheet is filed much after my retirement, my lord. I am entitled to get my pension on the very next day of my retirement, my lord. That is February 2015. In anticipation of the charge sheet is filed, my lord. And the decision, my lord, which I placed before your lordship squarely, my lord, it has been
No, actually, it says in case of criminal proceedings,
my lord,
on the date on which the complaint is made, complaint or report of a police officer of which see the date that the complaint is made,
my lord,
or the report of which cognizance is taken is made.
My lord,
the date of making the complaint is the date of judicial proceeding.
My lord, rule 7B, my lord, in case
Yes,
criminal, in the date on which the complaint
on the date,
or report
it should
of,
be on the date on which the complaint
or report of police officer of which the magistrate took cognizance, my lord.
Takes cognizance.
Magistrate takes cognizance.
Commas are there, sir.
My lord.
You should carefully read. So the correct way of reading is on the date on which the complaint is made. What kind of a complaint? A complaint of which the magistrate takes cognizance. He might take cognizance later. This does not say it will be the date on which the magistrate takes cognizance. That is not the language. The language is the date on which the complaint is made. Otherwise, if your interpretation is correct, it should have read the date on which the magistrate takes cognizance of the complaint.
My lord, so far as the, my lord, my little lord, my mere filing a FIR doesn't constitute a proceeding, criminal
You're
proceeding.
not on FIR at all.
Yes,
Here,
my lord. It is, but the charge sheet is filed only after my retirement.
Sir, you read this provision, sir. It does not use the word FIR. It does not use the word charge sheet. Just read that.
No, my lord.
Is there a word charge sheet there?
Cognizance, magistrate takes cognizance.
Of what? What does he take cognizance of?
My lord, in the instant case, since the vigilance.
No, we are interpreting this provision, sir.
My lord,
Ah.
complaint or report of the police officer.
So they don't use the word FIR. They don't use the word charge sheet.
My lord.
So there's a specific purpose for why certain words are used.
And my lord, besides my lord, rule, so far as the petitioner is concerned, my lord, there is a separate rule for sanction of the pension. There is a separate rule, not this rule, my lord. There is a government.
But that rule is silent on what happens if there are criminal proceedings pending. When that rule is silent, you have to come back to these rules.
77 rule, 7 repealed. And my lord, that rule repealed, my lord. And besides, my lord, I have been retired since 2015, my lord. And the charge sheet, they admitted that was issued in the year 2017, my lord. And in view of the decision, my lord, which I placed before your lordship, this court, the Honorable Division Bench of the Coordinate Bench of this court held that on the day there was no proceeding is pending in as much as no departmental proceeding or no criminal case, no charge sheet has been filed, my lord. That is at para 9, my lord. This was judgment compatible. May I please, my lord?
Yes.
On perusal of aforementioned provisions, it is made clear that 7(2)(c) explanation B that judicial proceedings shall be deemed to be instituted from the date when the criminal proceedings on the complaint or report of a police officer, the magistrate takes cognizance. As per Rule 49(5)(a), where the sanction of the payment of gratuity is delayed for more than a year from the date it is due, and under sub-rules 1 or 2, as the case may be, and such delay is attributable to administrative interest at the rate of so and so annum for the period beyond 1 year shall be payable on the amount of gratuity. Similarly, sub-rule 1 of Rule 66 provides that where a departmental or judicial proceedings are pending in respect of the government servant on the date of his retirement, he shall be paid a provisional pension, whereas sub-rule 2, which is supplement to sub-rule 1 of Rule 66, provides that no gratuity shall be paid to the government servant until the conclusion of the departmental or judicial proceedings and the issue of final order thereon. On cumulative reading of both the sub-rules referred to above, it appears that the same will apply only when on the date of retirement a government employee, departmental or judicial proceeding are pending against him. But these rules will not apply where there is no departmental or judicial proceedings against the government servant. But in the instant case, the petitioners have categorically stated that vigilance PS case number so-and-so, dated so-and-so by way of FIR, though was pending on the day of retirement of the opposite party number 1, that is on 31/10/12, but the judicial proceeding was started pursuant to the such vigilance PS case number so-and-so after the charge sheet was submitted on 22/7/13. That is much after his retirement, and as such, no cognizance was taken by the time the opposite party number 1 had retired from the service. Therefore, mere lodging upon a FIR cannot be construed that a judicial proceeding is pending against opposite party number 1. As it appears, though for the incident of the year 2000, Bhubaneswar PS case number so-and-so was lodged against the opposite party number 1, but charge sheet in the said case was submitted on 22/7/2013. Thereby, by the date the opposite party number 1 retired from either departmental proceeding nor any judicial proceeding was pending again before the authority for debarring opposite party number 1 from getting pensionary benefits as
counsel
due
to the
at that
petitioner, counsel to the appellant relies on the judgment of this court in State of Odisha versus Sushant Chandra Sahu, 2022 supplementary OLR 447, to urge that in terms of the rule of the proviso to rule in terms of the explanation B bracket 2 to rule 7 bracket 2 bracket small c of the Odisha Civil Service bracket pension bracket rules 1992, the appellant's pension ought to have been paid in full, since no judicial proceedings was pending on the date of his retirement. You see, notice, he accepts notice. List on 22nd August.
Item 56.
Lord, state is the appellant. Here, there is inordinate delay. There is inordinate delay more than 5 years. My only predicament is that this impugned order must have been complied with, but my only submission is that, your lords may hear me for a moment. The Honorable Single Judge has decided a point of law which is contrary to the notification of the state government, which was not brought to the notice of the Honorable.
So we'll say it will be not constitute a precedent.
Yes, constitute as a precedent, and the question of law left open to be decided.
There's an inordinate delay of over 5 years in filing the present appeal, and the explanation offered in IA number 3925 of 2022 is unsatisfactory. Paragraph, nevertheless, the appeal has been examined on merits. The grievance is that a circular of the government, which ought to have been brought to the notice of the learned single judge, was not placed before the learned single judge. And if it had been, the result would have been different. Paragraph. Given the inordinate delay in filing the appeal and the fact that the impugned order, which has not been stayed in all these 5 years, would have worked itself out, the court clarifies that the impugned order will not constitute a precedent. The writ appeal is dismissed with the above.
The question of law is left open to be decided.
Yeah, the question of law urged by the appellant is left open for decision in some other appropriate case.
In an appropriate case.
Item 57.
57, may I play this matter may take up next week?
Why? What's this?
In that case, I'm not prepared, madam. I am not prepared in that case. That's only that anti-reading regulation. Any day on Monday, my lord, may. Batch of cases are there.
There's a batch of cases here.
Yes, batch of cases.
This is the first of the batch.
This is the first of the batch.
Oh, at the request of. Then we'll keep on adjourning others also then at the request of counsel for the appellant. List on 3rd May.
Fine.
Item 58.
58, my lord, 14th September.
All right.
Item 59.
Also 14th September.
All right.
Item number 60.
My lord. Here I'm challenging the order of Honorable Single Judge, my lord. Here, the case of the petitioner that the petitioners was the highest mark in the matriculation applied for the post of Anganwadi workman, that is annexer 1, that is page 35 is the advertisement, my lord. There, my lord, in para 16, there is a specific time that 7 days after submission of form, 7 days time will be given for any objection, my lord. And there is no objection filed by any person, my lord, within that time. Or subsequently, my lord, annexure 8, my lord, they decided the result that the petition the highest mark, the 91.51, my lord. And the OP number 6, the 89.8% mark, my lord. He was selected. And the objection was filed by the OP number 6 on 16/4, my lord. That is beyond the after the date of objection date, my lord. And while the objection clarification pending for the Tahsildar, prior to that, my lord, on 21/4, the result was distributed, my lord. And petition did not divide to selected on the post of Anganwadi worker, my lord. Therefore, after this one court, and this one court directed to file an appeal before the appellate authority. And while the appeal is pending, during pendency of appeal, that OP number 6 was selected, he was resigned from the post, my lord.
Resigned,
Yes,
sir.
yes, madam. He was resigned from post. As I am the highest, secured highest mark, then I approach this one court, challenging the order, my lord. And now they are, my lord, without any cause, my lord, they rejected me as I am the first person secured in the mark, my lord.
But they've done the right thing by issuing a fresh advertisement, sir. You can apply the new advertisement.
No, because during pendency appeal, my lord, I am challenging the selection of opening of 6.
But she has resigned, sir.
My lord, that post is a challenge, my lord, here, my lord. Because I am the highest person.
Yes.
And by ignoring their illegal selected that person.
There's a circular that governs this, sir. 11022. That's the circular.
That is okay. But my lord, this will got passed in order judgment, my lord.
You have to tell us why that circular does not apply.
No, because my lord, first I am challenging the illegal, my lord. During that pendency of the appeal, my lord. Because I am the right, my lord, a right person to select that post, my lord.
Where is that circular, sir? 11022. Where is that circular?
That is so good, my lord. But is without merit, they only that, my lord, page 60, my lord, that CDPO Dharmasala submitted the written submission that Satyanshan and further stated that the respondent.
Have you followed the question I'm asking? No. What is the question I asked?
That's surprise there, my lord.
Where?
Not with me, my lord, but that is
somewhere there.
No, that is, my lord.
You have to imagine one circular. And we have to imagine it doesn't apply.
Order of the Honorable Court, my lord, there is, my lord, in favor of me, my lord. Because I have no right, my lord, because
you have no right.
Right now, I have no.
Yes, ma'am. Right now, I have no right because
you have no right.
They're illegally selected the person, my lord.
But all the words are all right. Somehow I think I will forget my English. It's better to take help actually. Yes.
My lord. That is, my lord.
Right. Recite. But there's no consideration of the circular, sir. The single judge here refers to a circular dated 11022. 11021, is it?
No.
11022. What is the circular?
Well, by the next date, I'll provide the circular, my lord. Because the date of admission that was disposed, my lord.
Counsel for the appellant wants time to produce a copy of the circular dated 110/2022, referred to by the learned single judge in the appeal order. At his request, list on June 22nd.
Item 61.
Please, my lords. This is an appeal challenging the order of the learned single judge dated 28/7/2022, wherein the direction was to consider the case of the petitioner there for rehabilitation assistance scheme.
It's all coming up. You see, notice 30th August. All right.
And this is another similar matter also, WA number 508 of 2023. 508 of 2023.
Let it come up. It will come.
Right.
Item 62.
This is also rehabilitation 30th August.
30th.
I just thought the interim order, my lords. Of the
yeah, staying.
Item 63.
None appeals dismissed.
Item number 64.
My lord, I pray give me sometimes of defer the removal of defect.
What's the matter about? Tell us.
The scheme itself is not in force.
Saubhagya Yojana.
Saubhagya Yojana to provide power supply. That scheme is not in force.
The prayer, the writ petition was for a direction to the opposite parties to provide all the facilities to the appellant, single quotes, under Saubhagya Yojana. Unquote, paragraph. The learned single judge has rejected the writ petition on the ground that the said scheme itself is no longer operational. Stop. Indeed, if the scheme itself is not in force, the above prayers could not have been granted by the learned single judge. There is no merit in the present appeal. It's dismissed as such.
Item 65.
Impugn order is at Annexure 1, page 10. Ma'am. Relying the order filed in OA number 452 of 2010, Honorable Single Judge has disposed of the matter. Though he stands on different footing, he has when during the course of inquiry, it was found that he has been appointed on the basis of 4 documents, and on that basis he has been terminated. And in that way, that reliance has been taken by the 452 of 2010. That's a different case where the termination has been set aside on the ground of jurisdiction of the authority not being the appointing authority.
All right, you say notice returnable. July. Interim order. There shall be a stay of the appeal order.
Okay. Item 66.
66, 14th 9.
14/9.
Item 67.
A rehabilitation matter.
30th August.
But around 67 million copy they have not given me. I am for the response number 1 million.
If you're agreeable, you can send it back, sir.
The past the disposal, it can be.
No, because after filing the third content mailer, they stated that they reasonably filed and given the number. So I appear mailer, here mailer. It is a matter of 2015 mailer.
It's not 2022 order.
All right, you say notice, he accepts notice.
Matter can be disposed of.
Yes,
he accepts notice 30th August, stay till then. All right.
Item 68.
Well, there is 7 months limitation mailer. And the matter is in 2017 they granted,
which
but they have not given the appointment.
Item 68 also.
Mailer?
We are now called out item 68, sir.
But in 67 mailer, I am saying, man.
67, we've kept it for 30th August. That day you argue.
But they have already given the 2017, but not appointment not given.
I see.
They are latest mailer.
All right.
Item 68.
68 regularization of service. Some similar matters have been fixed to 25th April.
Okay, 25th April, notice returnable.
Item 69.
69 and 70 job contract employee 14/9.
All right.
Item 71.
71 job contract 14/9.
72.
14/9.
Item number 73.
73, 74, 14/9.
All right.
And 75 also.
All right.
Item 76.
It may please your lordship, my lord.
My lord, the petitioners have challenged the order of honorable single judge granting liberty to approach the Orissa Education Tribunal, my lord, State Education Tribunal. As the matter has already been adjudicated in DIA case number 359 of 2011, my lord, it is not necessary to go to the State Education Tribunal. The question was before the DIA case 359 of 2011 as to whether the school is entitled to granting it from 1/6/1994. The school was granted it from 1/1/2004, my lord. They claimed that the granting it should be granted from 1/6/1994. That granting it was allowed. The DIA case number was allowed. it was held that the school is entitled to granted from 1/6/1994. These two appellants, they are not party in that GI case because they are peons, they could not contribute for filing the case. Now, all the members of staff got the granted from 1/6/1994. Salary from under Rule 9 of the Orissa Education, Recruitment and Conditions of Service of Teachers and Members of Staff of Rules 1974, my lord. Now, they claim that we are entitled to salary from 1/6/1994. That is only to be adjudicated. Again, it is not necessary to approach the State Education Tribunal.
Or if you say notice, who will accept notice? Mr. Kunti accepts notice on behalf of the opposite parties 1, 2, and 3. Notice will now go to opposite party number 4 by registered speed post returnable. 15th August.
77.
Sir, 8th May.
Item 78.
JC employment 14/9.
14/9.
79.
It may please your lordship, my lord. Here, my lord, your lordship kindly come to the writ petition that the petitioner is the auction holder, the present appellant is the auction holder of a Gram Panchayat pond for 3 years, my lord. He was the highest bidder, that SHG group, my lord. One Mita molecule also can come to page 50, my lord, 10 of the brief.
My lord, I am in VC offer on behalf of opinion number 7, respondent number 7, my lord. My lord,
let me complete.
I am not aware, but let you serve a copy on me, my lord. Case may be taken up next week.
Let me complete my submission, my lord. One Mita Malik, at page 10, you will also kindly see the cause title. He challenged the auction, finality of auction lease out to the present appellant, and she has abhorred your losses. I'll come to para 6 and 7 of that writ petition at page 6. The petitioner being along with the members of all other SHG in her personal capacity, he approached that on the date of auction, they could not reach in time. They reached the Gram Panchayat office at a belated stage. Therefore, auction was finalized. Let them give the opportunity to participate in the auction. During the pendency, my lord, the present appellant appeared and filed her counter affidavit, and the rejoinder affidavit was filed. Thereafter, the interim application was filed, my lord, by the petitioner that the writ petition shall be the writ petitioner name be changed and one Chauchika SHG be replaced as petitioner, my lord. This copy IN number was was solved just 1 day before, my lord. On the date of taking up that amendment petition, I prayed that a copy of the interim application has been solved last night. Let an opportunity to file the counter affidavit to that interim application. Without giving an opportunity, the Honorable Single Judge allowed that amendment, replacing the writ petitioner by another agency, my lord. Well, if that agency, the Chauchika SHG group, has any cause of action, they can file the separate writ petition. How can a writ petition be replaced by another writ petitioner, my lord? Your lordship, I'll come to the impugned order, page 61. The I file for amendment of the cause title of the writ petition had learned counsel for the parties. Considering the amendments made in this application after involving all parties, this court finds a genuine ground in the claim of the petitioner in bringing an application for amendment in cause title.
Some other petitioner has replaced the original petitioner.
Original writ petition was there, my lord.
This Mita Malik.
She has been replaced by an SHG group, my lord. How can it be, my lord? It is not permissible under the law. That if that SHG wants, then they can file a separate writ petition. The writ petition
pleadings were not changed. Only the cause title.
Only the cause title.
The cause title, my lord.
How can it be, sir? How can that be? What is the connection between Mita Malik and this SHG?
My lord, Mita Malik is the president of that SHG group. SHG group has prayed before this honorable court that they are prejudiced for taking part in the auction. and in the below price, my lord, that auction was held, my lord. It is the only she could have in the court ID. It would be that the SAG Churchika represented by the President Mita Malik.
Oh, I see.
But here it has been Mita Malik, President of the
It's not a different party, sir. Then it's not.
My lord, SAG is a different party. Your lordship kindly see the pleadings.
They have admitted.
Your lordship kindly the pleading. The petitioner says in the writ petition, Mita Malik, I went to participate in the auction when I
in her capacity as president.
Not in the capacity of president, my lord. Not in the capacity of president. My lord, you lordship kindly see that a writ petition is filed by a person or an agency when either legal right or fundamental right is violated. Here, Mita Malik has filed a writ petition that in her personal capacity, my lord, that in the averment she has stated, my lord, 2 paragraphs I am placing, my lord. The petition in her individual capacity, along with all the members of all other SHG, my lord, other SHG, they going to participate. As aforesaid them, when reached the Krishnadaspur Gram Panchayat office on the date fixed at about 11:20 am, the Sarpanch and the other authorities present, they are informed that the auction for giving lease the above amount has been over and lease have been granted in favor of the Balunkeshwar SHG group. But this is next paragraph 7, that it is respectfully submitted that petitioner along with other similar situated persons or other groups as above said reached the Panchayat are relevant. In her individual capacity, her allegation that she went to participate in the auction, not the SHG as a president of SHG. Nowhere it has been about, my lord.
No, your lordship kindly.
Nowhere in the writ petition it is about, my lord. That if that SHG, Churchika SHG has any cause of action, my lord, they can file a separate writ petition. It can be clubbed together and can be heard, my lord. In personal capacity, somebody has filed a writ petition. Now he will be replaced. That writ petition will be replaced by another agency group, are dependent by the present petitioner. How it is
kindly see the court title, my lord.
The court title she has described herself as the president of SHG.
That is her name has been described, my lord. She has given the designation. On her personal capacity, you will also kindly see the entire argument.
No, even the affidavit is president of.
They said that by designation is president, my lord.
Para 3 also she has stated that the petitioner is the president.
No, that is not there. You lost.
Para 3 of the writ petition.
Correct.
That the factual backdrop involved in this case is that petitioner is the president of a church SHG group.
So that's
president, my lord. She is the president. I am not disputing it, my lord.
But Churchika, she has filed. She has filed in that.
Churchika SHG has not filed the writ petition, my lord. One thing, my lord. Second, another amendment is sought for. That is, my lord, I have no objection, my lord. That they have implemented this present appellant, that auction holder, my lord. Now they have filed the amendment that Balunkeshwar SHG group be implemented in place of the present appellant.
Not Balunkeshwar, the Churchak.
That, my lord, that is, my lord, I have no. That is
Churchika.
Ma Churchika, my lord, Ma Churchika can file a separate writ challenge.
Not necessary, sir. All hyper-technical. Either the challenge in the present writ appeal is to an order dated 10th March 2023, passed by the learned single judge, allowing IA number.
Well, the opportunity was not given to my lord file counter affidavit.
Allowing an IA number
2157 of 2023, my lord. 2157.
2157 of 2023, thereby permitting the cost title of writ petition civil 28781 of 2022 to be amended. To stop earlier, the name of the petitioner in the said writ petition was Mita Malik. Full stop. The full description in the original writ petition itself was Mita Malik, President, Ma Churchika SHG Group. Full stop. The change that is sought to be brought about by virtue of the amendment is that the petitioner is now described as Churchika SHG Group, represented by its president Mita Malik. Paragraph. The court is unable to accept the plea of Mr. Mohanty, learned counsel of the appellate, that if the SHG Group was to be the petitioner, it ought to have filed a separate writ petition, and the present writ petition could not have been amended. Full stop. This is for the reason that even the original cause title of the writ petition clearly reflects that Mita Malik was filing it in her capacity as president of the Charchika Hesachi Group. The affidavit in support of the writ petition also reveals that. Consequently, the court finds no reason to interfere with the impugned order. The writ appeal is dismissed.
Item number 80.
That writ petition is a list before the cross-state bench.
Item 80, my lord.
One thing, your lordship,
On
your
1st
lordship,
April,
my lord, your lordship,
1st May 2023.
my your lordship may grant me some time to file the counter, the additional counter affidavit. Now he has filed that it has been confirmed that by your lordship, my lord.
On 1st May, you can ask the learned single judge that.
Item 80, my lord. The order number 4, my lord. Item 80, order number 4. 2 writ petitions are there before your lordship, my lord. Order number 6227 of 2016, my lord. This has already been disposed of. This matter is similar to 227 of 2016, my lord. In this case, my lord, the in this case, my lord, the petitioner challenged the order under Annexure 6, 7, and 8, my lord. Is as page 21, my lord.
All right. In view of the order passed with this court on 25th March 2021, in writ petition civil 6227 of 2016, bracket Messrs. Bhushan Power and Steel Limited, State of Orissa. The present writ petition is also disposed of in the same terms.
My lord, the annexures are similar. I have mentioned, my lord, the annexure 6, 7, 8 in paragraph 2, 4, and 5, my lord.
Or you want the whole order to be?
My lord.
Okay. All right. All right.
81.
None appears dismissed.
My lord, item 82. We have filed the affidavit and the video is also on VC.
Lordship, see order dated 4/1/2023 and 16/2/2023.
Let's see. Where is that affidavit? Photographs. Video is also there, he says.
Camera on karantu. Camera on karantu.
Just play the video, sir.
The photographs also I have annexed.
Where is it?
And the video is there. A Tahsildar, sorry.
Yeah, some photos are there. Where's the video? Video.
Photographs I have annexed.
Not video.
No.
Achha.
Now the Tahsildar for physical.
He's there. All right. You've seen the photographs?
Yes, yes, I have seen the photograph. Nothing, no work has been done. Now, summer has already arrived. There is scarcity of water. The ponds needs to be revived, Lord. Last 4 months.
At least garbage has been removed. Let's wait for the monsoon, sir. Something might happen.
There are some, don't say that no development.
No development.
No,
Lordship may see the photograph itself.
Because you are in
last 4 months.
Public interest litigation.
Yes, public interest litigation is no lesser than other litigations. Don't say like this.
Always you are saying that no work, no development.
So Jana, because of you, they've now put the bulldozer there, they've cleared the garbage.
Not cleared the garbage, they have shown some machinery, my lord. Only standing machinery, my lord. Nothing.
Now you will say so not a photograph of that place, some other place.
Don't be so uncharitable. You see the photograph?
Yeah, I've seen it.
Don't say it's simply standing there. It's not simply standing.
By this time, Lord, the pond should have been revived as your lordship directed. That's what it.
The water can't come overnight, sir. You have to create conditions for the water to come. Now that the garbage has been cleared, it will come. We should pray for a good monsoon.
Lord, may fix a date.
For what?
What?
For the water to come.
No, let them comply the order. My limited.
We have complied the order. We
Not
have
complied.
complied.
Lordship-
We are complying.
Lordship
And we are doing all developmental works there. And once the monsoon comes, your lordship has rightly pointed out, without the monsoon, how can we fill up the ponds?
Lordship
Even
has-
if there is a direction of the court, we cannot do it because it all depends upon the nature. My learned friends should realize
Lordship
it.
has specifically directed for revival of the pond. Now they have cleared the garbage. The revival has not been done. That
No,
once it
they
goes
cannot
out
do
of the
it, sir.
court, my lord,
It's a natural process. It has to be a natural process.
not natural. They have not taken out the wastage from the pond. They closed the pond, my lord. It was there over an acre.
Waste part they've taken out. Sir. The garbage has been taken out.
Not garbage from the pond. They are all filled up with all garbages, my lord. Only in the
If
upper
my
portion
learned
they have
friend is
cleared.
so serious,
What I
has
say,
he
my lord,
produced a single photograph of that?
Why don't
Only
you
saying. He's only saying last date also he said this and today also he's saying that. He's not producing any video photographs or videographs.
yeah,
or
lordship may give a
photographs.
chance. I will produce all the photographs, my lord.
Then
That's nothing.
after I say you will produce.
So that people can use it. That's not my anxiety, nothing else, my lord. That is in Sora, there is scarcity of
Government is
water.
more anxious than you at least because we are for the people.
My lord, in this matter, I am appealing for opposite part number 6, my lord. In this particular matter, I am appealing for the opposite part number 6.
Who are you?
I am a supervised contractor, man. I have undertaken some road works inside by the area, that pond. The allegation that I am filling up the pond by using 2 vehicles. The vehicles are the Luna, 2-wheeler Luna. After verification, a false affidavit he has made. Nothing doing a false affidavit against the opposite part number 6. Opposite part number 6.
All right. The Tahsildar Sorada, who's also present online, has filed an affidavit dated 3rd April 2023, including photographs to show that the waste has been cleared from the plots in question for the purposes of revival of a tank. It is further stated that the executive engineer R&B division Banjanagar has already been requested to take steps, open quotation, for complete revival of the tank, unquote, full stop. Mr. Jena, learned counsel for the petitioner, states that although the photographs show removal of the waste matter, much more needs to be done for revival of the tank. Full stop. He states that he will produce photographs to show what further work needs to be done. Let an affidavit be filed by the petitioner before the next date. The Tahsildar Sodara need not remain present on the next date. All right.
Lordship is fixing a date, madam.
Yes. I think when the monsoon is in full peak, we can expect something good. 25th July. 25th July.
Item 83.
83, my lord, no instruction.
No instructions.
Item
So
84.
my kindly be noted.
All right.
I'm appearing for the bank.
All right.
Item number 84.
84, as amicus had submitted a brief report, which is as a brief synopsis, which is there. In fact, this is indicated in the wrongly as synopsis filed by the petitioner.
By the amicus.
Also, the memo which has been filed not by the state but by me.
Okay.
Both the notings are wrong.
In the cause list, is it?
Yes, my lords.
I see.
The filing state was, in fact, the school and masters filing periodic affidavits with regard to the investigations which were being carried out.
The last affidavit is filed on 8th September 2021. So what is the latest position? I'll take instruction on this regard.
All right. The learned amicus curiae has filed the brief synopsis as well as a memo. Actually, there's also another matter in which we had taken, I think Mr. Prafulla Ratha was appearing, that Baud school.
Those schools. Yes, my lord. Those school, yes, the primary schools, man. Yes.
Yes, sir. It was the school of students. It has to be thought
ମାନେ ଇଏ
ସବୁ ଏଥିରେ ସବୁ ମିଶିଛି
ଏ ସବୁ ମିଶିଛି।
ଏଥିରେ ସବୁ ଅଛି
ଏଥିରେ
teachers midday ସବୁ
In that case, the school buildings are perhaps, school buildings are
The
amenities.
case involving infrastructure
Infrastructure,
and
correct.
dropout.
Okay, here it's about fake
teacher,
enrollment of students.
Fake teacher.
Fake teachers as well as fake midday students. meals also.
Fake students also.
Yes, ma'am. Midday meal siphoning of funds on midday meals.
That can be taken up with that so that.
That is better. If your lordship will tag that, the.
When is that coming up?
Sometime
April.
This month, Milord, April, sometime in this month.
27th April.
That's right.
All right. List this on 27th April. Meanwhile, a further affidavit be filed by the state government.
Regarding the up-to-date investigations.
Yeah, as regards the status of investigations. Right. Tagged with that. Yeah, list along with.
15395 of 2050.
Yeah, 15395 of 2050. All right.
Item 85.
May I please, my lords?
Yes.
So in this case,
you need
the lordship
to file a
were
reply.
directed as the last chance to file counter. They are not filing mirrors. Let them not be lords, but your lordship was specifically directed instruction by IA mirrors. There is a IA. But why there is a IA? Your lordship have seen the other day. Because my friend has produced a copy of the circular before lordship extending the date for filing return, for submission of audit report, and also mirrors for filing audited accounts, all this mirrors. That's what has happened. Even though they have extended the date of filing return, but so far as the consequences arising out of non-filing of return for which they have granted extension is still there. That is levy of interest mirrors. Under section mirrors, there are
Why is affidavit not being filed?
234H, 271 mirrors. So all these provisions, penalty, interest is there. So unless mirrors, they, and one judgment I am taking your lordship's attention by Honorable Justice Padiwar of Gujarat High Court mirrors. They have not preferred any SLP for the Supreme Court. I am giving a copy to my friend. In that case, mirrors, 2-3 extensions have been granted, but court didn't like to grant further extension. Here also we are not seeking extension. And the extension is granted by the department itself because of own laches.
No.
Just a minute. Because earlier, mirrors, just a minute. Just let me complete. Earlier, mirrors, Tata Consultancy was in charge of mirrors for providing portal. Government decided to give the portal to Infosys. And there is a press release which also have other application. Because of their own glitches, mirrors, people could not file their return. The department on their own invoking section 119 extended date. On a referendum, they also re-extended. Now the question is, Honorable Gujarat High Court said that the consequences which arises out of extension of the date for filing return should have been considered by the CBDT by issuing appropriate circular which they have the power. And in the operative portion, you will achieve the last paragraph mirrors. So they must come up with an appropriate circular in consonance with the circular which they have issued granting extension for filing return, which they have not. As a consequence, what is happening? Today, even if date for filing return that is allowed by the government CBDT circular, but consequentially interest is imposed. There thousands of cases is cropping up, and it will give rise to multiple thousands, lakhs of appeals across the country. So your lordship may kindly direct, milords, as a necessary corollary, let there be no penalty, no interest, milords, under the which your lordship have also said the other day. That paragraph 4 is now complied with. We don't have any grievance.
Lordship, kindly have a glance 31/3/2022.
How can they do that?
Order dated 31/3/2022. So far as revenue is concerned, we have already filed the counter.
We don't have. Section 234A, 234B, 234F, 271B. These are the provisions under which mirrors? No.
We have already filed counter so far as the revenue is concerned. But
last time you also directed Government of India.
Yes, that is what Government of India is department.
Yes, it is the Government of India who is to take a call on this.
Yes.
And Mr. Pali was appearing in the last occasion. He has not filed any counter because it is the government who has to respond.
So far as your prayer number B, I and 2 prayer has already been complied with by virtue of the notification issued by the CBDT. Only the prayer in this case, it is absolute prayer in the read application. Your lordship has decided whether the imposition of penalty to decide the section 234B, 234F and 271B, whether the alteration. That is the final outcome of the writ application, lordship. So by filing a miscase, entirely is the ultimately prayer has been come.
No, he's happy that the writ petition is disposed of, saying CBDT should come up with a circular to take care of the consequences of non-filing of the
absolutely correct
tax audit reports within time.
Correct. That point, Milord, I have issued later to the.
But no counter is also filed.
I have filed counter, Milord. Yes, sir. Milord, therefore, Milord, I want 7 days time. I will not, because of March, Milord, I have 25th or something, Milord, I have instructed. But I have not yet, Milord, 1 week time, Milord, said that can be disposed of after 7 days, Milord. Only 7 days time, Milord, be granted. So, for this, in this case, I will take for absolutely, but I am correct in primary instruction so that it can be disposed of as my senior.
Mr. Pari was appearing last time. He made a commitment for the court.
I have nothing to say so far as the government of India is concerned. So
despite last opportunity having been granted to the main writ petition, having been granted to the Union of India to file its reply to the present petition, no such reply is forthcoming. Counsel for the Minister Sahul and Senior Counsel to Petitioner places before the court copy for judgment dated 13th January 2021. In Special Civil Application number 13653 of 2020. Whereby similar issue concerning
IA number 4378 of 2020.
non-filing of returns and tax audit reports within time was being dealt with. Full stop. There, the Gujarat High Court took note of the fact that the Central Board of Direct Taxes, (CBDT), had kept extending the time limit for submission of the returns of the tax audit reports. Full stop. When the court was urged for directions to the CBDT to further extend the due dates by invoking its powers under Section 119 of the Income Tax Act 1961, the Gujarat High Court declined to do so on the ground that, open quotation, the matters relating to revenue, unquote, interference at that stage would have, open quotation, far-reaching implications. Good.
If you are permit to interrupt us, that's now we don't have refund because they have extended. We are happy with that.
Correct. No, I know.
Minus.
Ultimately, the Gujarat High Court observed as under page 5188. Paragraph. Mr. Sahul and the senior counsel for the petitioner states that, as already noted by this court in its order dated 31/3/2022, the circular dated 11 January 2022 of the CBDT has already extended the timelines for filing of returns and reports for assessment year 21-22. Stop. Both prayers 4 and 8 of the petition already stand taken care of. Stop. The only apprehension remaining is that
B, prayer B, my lord,
is that the department should not charge interest under Section 234 capital A, 234 capital B, late fees under Section 234 capital F, and penalty under Section 271 capital B for filing of late returns. Paragraph. Considering that there were technical glitches spoken of in the writ petition which prevented many assessees from filing the returns of the tax audit reports within time, and taking a cue from the aforementioned judgment of the Gujarat High Court, what is the cost title for this?
Cost title is, I'm sorry, it is here. This is Gujarat Federation of Tax. I am giving one copy to a lot. This one I will permit to replace. The first copy has the
Gujarat Federation of Tax Practitioners
Gujarat Federation of Tax Practitioners versus Union of India.
versus Union of India, Supra. Right. This court
Last paragraph.
observes that the CBDT should consider issuing an appropriate circular clarifying that by granting the extension of the deadline for filing returns or tax audit reports, correspondingly, the above provisions would not be invoked for non-filing of returns as long as it is done within the extended deadline. Full stop. A copy of this order be communicated to the CBDT for appropriate action. The petition is disposed of.
You also will dispose of them.
Okay. IA does not survive in its
Will I pray my Lord's Belows to refer to annexure?
You put the IA petition and IA. Sorry.
Annexure 2, page 33, the press release. Just your Lordship may kindly keep an eye on this. Page 2, annexure 2, page 33. Just for a moment, your Lordship may just tell it.
Lordship corrected glitch-free experience. Right. Correct.
Obligation.
In 86. My lord, in 86, we have filed an affidavit.
In the last occasion, your Lordship had directed the collector Kotak, and last chance was given to file a affidavit regarding the factual aspects. But last 2 occasions, they are not filing. Last chance was given.
Lordship may
Order,
see.
order number 4 and 5.
Just
We
wait.
filed an affidavit.
We have filed affidavit. Just wait. On
No copy has been sent.
Yesterday, we have filed the affidavit. I am serving a copy of it to him. Let him file rejoinder. Your Lordship take it up and
Please give me the copy.
in person. In person.
All right. Sthitiban status, sir. No encroachment. And affidavit
No copy.
2023 has been filed by the collector stating that he conducted an inquiry and found out that Srimati Chabirani Raut is promoting pisciculture farming over the land in question and has developed a water reservoir for that purpose. Semicolon, she has not encroached the water body as it is a Rayati land and recorded under Sthiti 1 status. Full stop.
May I please, Lord?
It is further pointed out that as per the record position, open quotation, the land in question is private one and there is no habitation within 200 meters of the said land. Unquote. Consequently, it is submitted that the question of eviction of the tenant from the said land does not arise. Stop. Copy of the ROR has been enclosed. Copy of the ROR and the Tahsildar's report has been enclosed with the affidavit. Stop. A copy of the above affidavit has been also handed over to the petitioner.
My lord, no copy has been served on me. In order number 4, your Lordship has directed rejoinder to the affidavit file. So
My lord,
let
in
me
this case,
direct
Mr.
to
Bahali
file a
was
copy
appearing.
and file a rejoinder.
Mr. Bahali was appearing. I don't know him. He is also, I think he is in person appearing also because he has no gown. So I don't know whether he's appearing.
Let him this solve the copy and finally.
Right now I'll solve it.
Solve me a copy, madam.
No further
I'll
directions are got.
adjourn it to some other.
The petition is disposed of. All right. Yes.
Can we जाने भी अपन?
Item 87.
Count up इनकी ऐसे ही ना. In person.
Wait, please, your lordship. This is a case where the petitioners have challenged the decisions of the opposite party in shifting a primary school that houses students from class 1 to class 4, aged between 5 to 10 years, to the campus of a high school, my lord. That will require the students to cross a 4-lane highway. That will also a flyover is also proposed to be constructed on that. And on that issue, my lord, your lordship had issued notice and also granted status quo initially. On the last occasion, we had sought for time and your lordship had vacated the status quo and we have filed the rejoinder in the meanwhile. In the counter affidavit, my lord, we have sought the copy also. The receipt is with us.
I am for the occupant 9, my lord. I have also filed a counter affidavit. Now the school work is going on smoothly. I have annexed my photograph of the construction process. I have page 18. And now the school is within the same campus, all advantages and to the students.
Man, the sole issue here is the safety.
Rather, the allegations what my lord is raising, that is detrimental to the interest of the student.
Man, the sole issue is the safety of the students who are aged between 5 to 10 years. It is impossible to expect them to see the normal safeties when they will be exposed to the accidents on the road, my lord. They will have to cross a 4-lane national highway, my lord. Further, my lord, from their villages to the proposed location where the school is being proposed to be shifted, that is above 1 kilometer, my lord. That violates the Odisha right to education rules of 2010. That says that for construction of primary schools, that should be within the limit of 1 kilometer, my lord.
This is within 1 kilometer.
No, my lord. In the counterfeit, they have said that from the old school to the new location, it is 200 meters. That is not 200 meters. That is above 200 meters. But as per the rules of 2010 rules, the distance from the houses of the students, means the villages, to the school, that should be within 1 kilometer, my lord.
What's the distance?
The distance is 1.6 kilometer, my lord. That I have said in my petition, my lord. Further, my lord, also in the rule 6 clause 3, my lord, that says that where there are...
All right, if a copy of the rejoinder be served on counsel for the opposite parties during the course of the day. List on. 12 July.
I pray that the status quo be restored.
No, the last time only vacated, can't immediately put it back. Yes.
Item 88.
My lords, in this case, we're moving on. I mean, that question of his involvement with the bank, that's a closed chapter. So in the meanwhile, my lords, the managing committee has been constituted. There have been elections held. And now, of course, my lords, I'll have to produce those documents and probably ask for permission because my lord's order of 16 February at para 10, while directing opposite party number 9 was the concerned gentleman to hand over charge forthwith, handed over charge to the RCS, the Register of Cooperative Society. So if my lords will give me 2 weeks, I'll bring those documents on record that the managing committee is constituted and then ask for formal permission if the managing committee can take over.
Yes, yes.
That the interim order is already compliant.
Right.
Managing committee has already
Sunil Matthews, learned counsel appearing for...
Pardon, my lord. In this matter, I am appearing for OP number 7. I want to file counter of...
Who is preventing you, sir? Nobody prevented you. Counsel, Mr. Sunil Matthews, learned counsel appearing for opposite party number 8, informs the court that the order dated 16 February 2023 has been complied with by them. He adds that a fresh managing committee is in place with elections having been conducted. He will place the further developments on record by way of an affidavit, which will be filed before the next date of hearing. You can have it after vacations now.
Yes.
Very well. My lords, if it could be before, because I'll tell you the problem.
You file an application then for vacating, for modifying
we'll have to, we'll have to seek your permission as well as...
So you file that application.
Very well.
No problem.
Very well.
Well, interim order to continue till that date.
Yes, yes. Interim order to continue.
That is no question of
We have already
that gentleman
complied.
coming back.
We have already complied.
No, if
We have already complied the interim order.
List on 28th July. So if you want it earlier, you can always file an application.
Very well.
Okay.
Item 89.
89, I'm in virtual mode, but I'm appealing for the upper line. I have challenged the order of the Honorable Single Judge. Initially on the ground that the period the respondent was in custody or it was in initially he was convicted by the trial court, then it was affirmed by the appellate court, then revisional court acquitted him. Then we reinstated him. Now the single judge was directed to pay the salary for the period he was terminated or dismissed from service. As your Lordship is aware, no pay, no work is the basic principle. I have also lost before a Lordship on many cases where the Lordship said, even there is no fault of the petitioner, back wages should not be given. So my limited submission is...
Lordship may see page 18, my lord. The entire order, my lord, sums up that the Honorable Single Judge has remanded the matter to the bank to recalculate the dues, my lord. Now, Lordship may kindly see the bank, the conduct of the bank, my lord, on 4 occasions they have not appeared before the Learned Single Judge, for which the Learned Single Judge proceeded with the matter, my lord. A departmental proceeding was initiated against me. 2 charges were framed. That is in para 15, Lordship may kindly see, charge number 1 and charge number 2. They could not be proved, those charges, my lord. Apart from that, page 16, Lordship may kindly see, one criminal proceeding was there. I was convicted. I challenged in appeal in revision before this honorable court, and this honorable court has been pleased to dispose of the revision, allowing the same, my lord. And the Lordship may kindly see page 17, the finding of this honorable court, my lord. Page 17. The mens rea is not there. My involvement has not been proved, both in departmental proceeding as well as in criminal proceeding, my lord.
No, and how all the treated as being on service? That's the question.
My lord, my lord, I have been...
See, what we can clarify is it will be counted for the purpose of pension. But not that you will get arrears of pay for that period.
My lord, I have been honorably acquitted. So, my lord, I go back to the stage where I was, my lord.
But if you don't work, you can't get paid for that,
lord,
sir.
Yes, I'll
count for the purposes of all other purposes, like for instance, fixation of seniority, fixation of pension. It will count for all that.
Lordship, yes. Lordship, kindly see what was the order which was challenged by me before the Honorable Single Judge, page 14, my lord. Lordship, kindly see. It was they have reinstated me with the conditions stipulated therein. The conditions are, my lord, that the period of dismissal would not be treated as period spent on duty, and accordingly the petitioner would not be entitled for any other allowances and any other privileges, including service seniority and promotions also.
So that promotion is one thing.
Yes, my lord.
Other privileges, including service seniority.
Yes, my lord.
So we can clarify that this period will count for the purpose of fixation of pension.
So also seniority, my lord. In case I am found to be senior, my lord, my pension will be fixed accordingly.
You're not anymore. Where will seniority come in?
My lord.
You're not in service.
I was not in service, but honorably acquitted.
It doesn't make a many.
What my humble submission is, my lord, the bank has interpreted the order passed by this honorable court and reinstated me with conditions stipulated therein. That's my only condition. Now the bank
now you've superannuated.
Yes, now I'm 65-year-old now. After your lordship's last order, my lord, I approached the bank. The bank has now given me a calculation of 7 lakhs, 7,13,000 on their own calculations. According to my calculations, it comes to much more than 20 lakhs, my lord.
No, because you're counting this period as being in service.
Yes, lordship directed, therefore we have prepared a calculation.
Yeah, but Mr. Mishra, for pension, you'll have to count the service.
Yes.
Yes, ma'am. Yes, ma'am. So for the salaries, I am opposing, my lord.
Right. You see the controversy.
I'll also be, on one last submission, I'll also be eligible for 3 financial, my lord, increments during the period in which I was there. Let them consider that also, my lord. That's my only humble secret. Because during the period which I worked also, I'm entitled to some increments. That they have not calculated.
What about that, Mr. Mishra?
Well, unless somebody is working, well, how the increments will be calculated?
No, for the period I have worked.
No. For the period during which he worked, he says he earned increment.
Yes. So far, the period he has worked, we have nothing to say. We are confined so far the area salaries are concerned.
Then how will this get sorted out? You have to...
You will examine, direct payment, accept the salary.
All right. The controversy in the present appeal by the State Bank of India against the impugned order dated 13th February 2019 of the Learned Single Judge, disposing of writ petition civil 6206 of 2012 filed by the respondent, is narrowed down to calculating the benefits, financial benefits extendable to the respondent who has come during the pendency of the appeal, superannuated. Paragraph. The brief facts for the purposes of the present appeal are that the respondent had to face criminal proceedings during his service, in which he was acquitted honorably and therefore sought reinstatement. Full stop. While reinstating the respondent, the bank made it conditional that he would not be entitled for the period during which he was out of service any of the benefits, including service, seniority, promotion, allowances, etc. Stop. This has been held by the learned single judge to be impermissible, and a direction has been issued to the bank to extend all the benefits due and admissible to the respondent in accordance with law. Paragraph. With the respondent not having worked during the period when he faced the criminal proceedings.
From 97 to 2009.
That is 1997 to 2009. He cannot be expected to be paid arrears of salary on the principle of no work, no pay. Full stop. Nevertheless, that period would have to be counted for the purposes of fixation of his pension. Paragraph. Secondly, as regards the plea of the appellant that during the period when he was in service, he had earned 3 financial increments. That is an issue that will have to be examined by the bank and the benefits worked out accordingly. Mr. Kali Prasanna Mishra and a senior counsel appearing for the bank states that within a period of 4 weeks from today, the bank will rework the financial benefits due to the respondent. As regards the pension and financial, as regards the financial increments earned by the respondent and the consequential fixation of pension, but including the period during which the respondent was out of service. Full stop. The details should be communicated to the respondent not later than 1st July 2023. 1st June 2023. List for hearing on 26th June.
Melon.
26th June.
Item number 90.
In this matter, Your Lordship, I appear for respondent 2 to 4. There are some factual aspects this has come against the dismissal of the case by the learned honorable single judge. Some factual averments required to be answered. So I need some time to, if Your Lordship permits, to give a reply to this. Because what happened on that day when the matter was dismissed for default and thereafter. Such factual averments are at page 8.
Delay of 221 days.
My lord?
Delay of 221 days in filing the restoration application.
Restoration application was filed.
With a delay of 221 days.
I had filed an objection. His objection, he says that the copy of the objection was not served on him, though it was offered to him, served on him. And my associate was also there who had served in my presence. I was there and he was there. Now the appellant says that he was not served with the petition, and in any case, the honorable single judge dismissed that. And taking note of the averments that I had made at paragraph 8 of that reply, Your Lordship.
Already asked for time in February, sir.
Here.
Seem to have asked for time in February itself.
Yes, that is right, my lord. I could not file it
because the respondent could not come, Your Lordship. Otherwise,
Why is this such a hugely contested matter? What is so special about it?
special about it, we were arrested dead of night, for which this lady officer, my lord, she has been penalized by the Human Rights Commission by 50,000 rupees was awarded. And it's against that she is fighting this battle. And in the case in which we were arrested, all of us are exonerated in that.
How does it help that her appeal is dismissed for non-prosecution? Her petition is dismissed. How does it help you that her petition will be dismissed for non-prosecution, sir?
No, Your Lordship, look at the conduct of the appellant, Your
This
Lordship.
can hardly be the ground, sir. Ultimately, somebody has to hear a writ petition on merits.
Your Lordship,
it helps nobody. Ultimately, you know what happens in all these matters. If you take such a rigid stand, at one point it will get restored to say, let the writ petition be heard on merits.
Why it was this?
If you want, we'll put you to her to terms. She can pay some 3,500 for costs.
That is not important, Your Lordship. May kindly look at page 29. Your Lordship, may kindly look at page 29. This is what I had quoted, and this is how the. Page 29, my lord. Paragraph 4. This court issued, Your Lordship finds that page. Page 29. Impugn order, my lord.
Yes.
This court issued notice to the opposite parties in the limitation matters. Pursuant to that, an objection was filed with the opposite party through
If you want, we'll subject her to terms. This is all.
There is another.
Serves no purpose. Ultimately, the writ petition has to be heard on merits.
I understand, Your Lordship. But another aspect to it, whether I will have to examine, my lord, whether the writ appeal will be maintainable as against an order of this nature. That is also one thing, my lord. It's not an order in a writ petition. That is to be examined, Your Lordship.
It is an order refusing to restore a writ petition. Again, if you don't stand on this high technicality, we might as well say that the writ petition should be disposed of in a time-bound manner. We will make sure that counsel is ready, available before the single judge. Will not seek adjournment.
Your Lordship, may
Pleadings are
kindly
complete in the writ petition.
My lord,
pleadings are complete in the writ petition.
my lord, Your Lordship, may kindly look at the affidavit my associate is filing today in court.
They filed a false affidavit regarding my presence on the day when it was dismissed for default. I filed a petition. Wait. I filed a petition to take appropriate legal action for filing false affidavit, and that is pending. That is the CMAPL 139 of 2022. The IA is 306.
No, my question is in the main.
So here, this court.
Let's not enter into all this. In the main writ petition, are pleadings complete? In the main writ petition, are pleadings complete?
No, that is what I'm saying. The main writ petition, I appeared at a later stage and filed an amendment petition. Because there is something was pleaded which is contrary to the record. This is a police officer. She discharged her duty. Everything is on record that it was she went and arrested before sunset. And inadvertently, there was something wrong with it. I filed the petition for amendment. That petition was listed. But what happened, my lord? While transferring the case, the laws appearing for the other previous to my appearance, their names were not deleted. So my name appeared after 2-3. So at one point of time, even though your lordship will see the entire petition I have stated in the appeal you have given, every time I was alert, but somehow or other he missed my name because I never appeared number 2, 3, 4 in my life, excepting 99%. My name, because I appear and I appeared the first. So the name appearing in the previous council could not be deleted. That was the misunderstanding. And the most important thing that, my lord, for 7 years of the delay, without filing a condonation of delay, our Honorable High Court has condoned the delay without a petition also. And that has been affirmed by the Supreme Court in a review petition. So condonation of delay, what your lordship said is...
1 minute.
I would not have objected to this subject to lordship had the appellant been fair to the court. My lord might look at...
I am much more than the fair. I am much more than the fair.
My lord, the first hour he takes time to the after lunch.
There is no record.
My son was present there. That is the affidavit. First hour he seeks time. Let it be taken up after lunch.
Let her pay whatever costs. If you're so insistent, you can pay costs of 3,500 rupees. Be done with it. Let the writ petition be heard.
My lord may grant me 7 days time.
For what?
I'll check this maintenance department.
No need.
My lord, maybe I think it is wanting.
It's all right. You say.
And before your lordship, my associate has also given an affidavit also who was present in court on that. That copy was served on him.
Yeah. The writ petition civil 1639 of 2014.
And your lordship may also look.
Filed by the appellant.
A document was
seeking the quashing of
offered
an
to him.
order
He
dated
did not accept it.
12th July 2013, passed by the Odisha Human Rights Commission in OHRC case number 3206 of 2012, whereby compensation of rupees 50,000 was paid in favor of respondents 2 to 4. Has his compensation amount been paid?
Madam,
Compensation amount has been paid.
I'm not able to hear.
Is the compensation amount paid, sir?
Yes, yes, they have already realized.
State has paid that.
Right?
No, they realized from me also. No, absolutely. There's contrary to that order is out and out illegal. By
Okay, it's all right. It's all right. But we are not deciding
Well,
that here,
I
sir.
understand.
Under section 18 bracket small a of the Protection of Human Rights Act 1993. After rendering a finding that they were arrested at the instance of the present appellant, who was at the relevant point of time the investigating officer attached to the Bhubaneswar Mahila PS. Dealing with PS case number 215, dated 11th May 2012. Paragraph. A perusal of the record of the writ petition reveals that notice was issued in the writ petition on 4th May 2015. But till the dismissal of the writ petition for default for non-appearance of the counsel for the petitioner on 19 July 2017, none of the opposite parties in the writ petition, that is the respondents herein, had filed their replies to the writ petition. Paragraph. The controversy, as far as the present appeal is concerned, stems from an application being CMAPL 139 of 2018, preferred by the appellant, seeking recall of the aforementioned order dated 19 July 2017 and restoration of the writ petition. Full stop. Along with it, IA number 69 of 2018 had been filed for condemnation of delay of 221 days in filing the application for restoration. Paragraph. From the impugned order dated 28 September 2022 of the learned single judge, dismissing the IA and consequently the CMAPF, it appears that one of the questions that arose was whether counsel for the appellant had in fact appeared in the first call on the date that the writ petition had been dismissed for non-prosecution, and that after seeking passover in the second call, he had failed to appear. Paragraph. A perusal of the order dated 19 July 2017 shows that it does not reflect the name of any counsel whatsoever. Full stop. Therefore, on a perusal of the order itself, it is not possible to ascertain whether any counsel appeared in the matter when it was heard, when it was listed, when it was called out. Paragraph. The impugned order sets out the averment in an affidavit of objection filed by the respondents 2 to 4 herein. Although the court itself has no record of either appearance or non-appearance of counsel. Paragraph. This court is of the view that in matters concerning restoration of a writ petition, a liberal approach ought to be adopted because ultimately a client should not suffer for any lapse on the part of the counsel. Stop. The better course would be to subject the appellant to terms by requiring her to pay costs to respondents 2 to 4 for the inconvenience caused to them as a result of non-appearance of counsel for the appellant. Consequently, it is directed that subject to the appellant paying respondents 2 to 4 costs of rupees 3,500 within 2 weeks from today, the impugned order shall stand set aside and both IA number 69 of 2018 and CMAPL 139 of 2018 will be considered as allowed, meaning thereby that the order dated 19 July 2017 of the learned single judge will stand recalled, and writ petition civil 1639 of 2014 will stand restored to the file of the learned single judge. It will now be listed before the learned single judge in the roster bench for hearing on 12th July 2023.
Little more.
All right, 14th August 2023. Full stop. The respondents herein, who are opposite parties to the writ petition, will file their paravise replies to the writ petition not later than 17 July 2023, and the appellant herein, who is the writ petitioner, will file rejoinder thereto, if any, on or before 14 August 2023. No further time will be granted to any of the parties for the above purposes. Considering that it's a writ petition of 2014, a request is made that the learned single judge should proceed with the hearing of the writ petition on merits and dispose it off as expeditiously as possible.
May I make a small preamble? The names of the previous counsels appearing before me may be deleted if possible.
Where in the cause list?
No, from the appearance, yes. Cause list as well as from their appearance may be
The
ignored
registry will
because they transfer the
ensure
case
that
to
the
us.
name of Mr. H.S. Mishra is correctly reflected as counsel for the petitioner.
No, correctly it is reflected, but it's sometimes nowadays, of course, in the computer it is not likely to be.
Anyway, now you know the dates.
Yes,
It's all dictated in your presence.
Yes.
Whether your name is
Correct.
there or not,
Correct.
you should appear.
No, the computer is also helping even if it is in the midst of the many lawyers, so it is indicating.
All right. All right. This is better because ultimately you should have one forum where it is heard on merits. That's all.
That is all right. This lady officer, my lord, was also given another punishment, 75,000 by the same
It's all right, sir.
human rights.
Ultimately, you're going to file your reply.
It's a
You can
case
bring
I'm
all this on
fighting.
record.
It's a case I'm fighting. Your lordship has not seen the old lady, my client, your lordship. She was dragged from her residence.
See, the point is, the more severe the facts, the more fairer has to be the procedure.
No,
ultimately, what's the point in losing on facts but winning on procedure?
At least bar gains, my lord, 221 days delay, your lordship has condoned. So we'll take advantage of that in writ appeals.
This court has condoned delay of 7 years without an application for condonation of delay, and that has been upheld by the Supreme Court. So better that can be taken in every cases because as your lordship said, people should be hard on merit unless there is statutory bar.
All right. Passover matters. Oh, sorry.
One Passover, man.
All right.
Item number 37. Item 37, Pastor matter. My lord, there are some ineligible copies that is filed. That is why in the first hour I took time. I was seeking for time, but my lord, I refused it. On that document, I may be permitted to place, my lord. The order of the Honorable Single Judge at Annexure 11 is the subject matter of challenge here. Here the dispute, there is no dispute with regard to the position of law. So for the Honorable Single Judge has decided that the senior most teacher will be the principal in charge of the institution. But here is the deviation, that part has not been taken note of. Opposite part number 5 is the senior most, but no, sorry, 6 is the senior most person. but she was not allowed to function in the post because of during her tenure as principal in charge for about 15 years, she has defalcated huge sum of money, and that has been found in a special audit conducted by the state government. And that audit report, my lord, will only one page 24 may kindly be seen. 36,38,349
No, but
was
the
shown
same
as
question I keep asking in all these matters. This is an order of 20th September 2022. Has it been implemented, sir?
which one? No. Implemented in the sense, my lord, she has been allowed to function because of the order. But I am challenging if that person is not allowed to continue. Such a person is not allowed to continue because she is the principal of the in charge now. During her tenure as a principal in charge, he has defalcated 36,38,000 and directly recovery was directed 1,54,000. Till that, this is after a report of 2013. She has not paid it. She has fight out the litigation only because he want to be principal. So that is square up everything. Just because he has entered into the institution by the order of the Honorable Single Judge, now what she has done, she could not manipulate things with the bills and vouchers. She has submitted some photocopies and produced it to the authorities to get a clean sheet. And this is the position for which another petition is filed with the Single Judge. But my lord, kindly see who is the government circular at page 135. That was before the Honorable Single Judge. Kindly see. Sorry, 134, sorry. With regard to the appointment of the principal, what does it say? The way back from 1989 that is holding the field till that it is there. It says preferably the senior most person, not necessarily the senior most person. The Honorable Single Judge proceeded in the matter because that challenge was that 31/8/2020, another circular has come. The seniority will be fixed on the basis of date of birth, not on the date of joining. That was the subject matter. Incidentally, I was the counsel in that particular case. And the Honorable Court has held no. Date of joining should be the determination of seniority. And that is why the case was decided. And the Honorable Single Judge applying that case decided this aspect without taking note of this fact, this particular fact that on the basis of the audit report, a financial defalcation has been pointed out. Till date, she has not complied with that. Now, by virtue of the Honorable Single Judge, she has now been allowed to continue as the principal in charge.
But what
This is the only
from
point.
instituting separate proceedings for that?
Pardon?
What prevented anyone from instituting separate proceedings?
The proceeding was instituted by the sub-collector. Matter was referred to the audit. Because audit, the college cannot have their own mechanism to go for audit.
And then
special audit was directed and the government conducted the special audit through each auditor. And thereafter the report has come. Report was confronted to her. Till that she could not comply the report. That is the allegation.
No. So what further happened? Did government take further action?
No, government can. There is a legal fallacy. What happened in all the aided colleges, there is a governing body. Now for this institution, sub-collector is only appointed as the president of the governing body. A full-fledged governing body is yet to come. Government is not reconstituted.
A separate cause of action. I don't know why you're mixing up the two things.
No, mixing up.
As far as financial irregularity is concerned,
yes,
you can either file a criminal complaint or you can institute separate proceedings for action by the government. You can take a complaint to the department.
My lord, for that,
this is what an aided institution, right?
Yes, for that a governing body is required. Government is not constituting a governing body.
Use these proceedings to finish to settle that issue, sir.
No,
this was merely who should be principal in charge on the basis of seniority. There's nothing else here.
But a person with such a character,
any other issue you may have with the person, you have separate proceedings for that.
No, only proceeding is my lord, such a person with such a
but that you have not come to the court. You're trying to get this order in her petition. How is that possible?
No. This is the next principal. I was the principal in charge. In her absence.
This proceeding in which the impugned order has been passed was not instituted by you.
Yes, it is instituted by me. On mine, yes, the writ petition was filed by Banani Patnaik. Dr. Banani Patnaik has filed the case because she was approved by the government in way back in 2011 to function as principal in charge.
Sir, this is writ petition 720773. Petitioner is Kavita Mahapatra. I don't know what you're trying to say.
My lord,
what the impugned order has been passed in 20773.
I was the opposite party there, my lord. Sorry, my lord. I stated wrong.
I think I was telling them. I will forget my English. I will completely forget my English by the time I finish.
For that,
I was shocked that I've made a very fundamental error.
I'm sorry, my lord. This is justice report. I was there in the opposite party, my lord.
There's a new definition of slip of tongue.
No issue, my lord. So see,
So at least I am correct that you are not the writ petitioner.
No, I am the opposite party.
You are the opposite party.
Because
so you never instituted proceedings for action to be taken against her for financial irregularity.
Yes,
sir.
Yes.
What proceeding did you institute?
Page
Tell me.
25, my colleague. Page 25. That was the order before the resolution. Page 25, Annexure 2. The sub-collector come president, 25/4/2013.
No, this is some sub-collector passing an order.
Being the
What
president.
did you do? My question is, what did you do on the basis of this resolution?
This resolution, I was the secretary of the institution.
Sorry?
Sub-collector being the president, she was presiding
So
officer and I was the secretary.
Yeah, together both of you, what did you do? You simply kept quiet.
This resolution was passed. Matter was remitted. Government interfere in the matter. Government has directed there will be a special audit. You send it.
You have to take matters forward, sir. You have created one new cause of action, correct? You have to take it to the logical end. Who's preventing you? Who prevented you from taking this to the logical end? Somebody has defalcated money. There is CRPC, there is IPC. Did anyone prevent you from filing a criminal complaint? Nobody prevented you.
That is also that all the records are there. Because
who prevented you from taking that issue forward?
Now, my lord, she is in the helm of the affairs.
Mixing up.
She is in the helm of the affairs. She became the principal.
The more you keep quiet, doing nothing, this is what will happen, sir.
My lord, that is why I am explaining.
You are in her petition, you want to introduce a new cause of action and say she has to be finished. This is very convenient.
You
don't want to lift a single finger to actually institute proceedings. In her petition, you say, no, I will make sure that all these facts come in.
My lord, may be permitted 1 minute only. This process, I was the principal in charge. See, after the judgment in that WPC 230 has come, that the senior most person will be principal. She has instituted this case, saying that I am the senior person. I should be registered as principal in charge instead of Bonani Patnaik. But the Bonani Patnaik during her tenure could not be taken up the matter because there was no approved governing body. Because, my lord, the judgment of this honorable court says that either the principal...
We're all illiterate. Completely
this
illiterate.
Is related. What it is related to this extent, I am answering the question put my lord to me. My lord, why you have not taken? You means, my lord, it is the governing body. There was no governing body for the period for which I was the principal in charge.
The only ground on which the appellant seeks to challenge the impugned order.
May just one
September
second,
2022.
May I interrupt? My lord, may kindly suggest, my lord, call from my lord's mouth. Let the governing body take its decision.
Yeah, what?
Yes, that must my parents.
Allowing writ petition civil 20773 of 2021 and 25344 of 2021 filed by respondent Mufai, whereby she has been asked to be respondent 6, whereby she has been asked to be reinstated as principal in charge of the Rani Sukadei Women's Higher Secondary School. Is that there were serious complaints of financial irregularities against respondent 6, which was subject matter of certain inquiries, which could not be taken forward because the governing body of the institution was not constituted. Paragraph, Mr. Dash, led counsel appearing for the appellate states that the position is not changed even today, as even today there is no governing body. Paragraph. Be that as it may, this appears to be a separate cause of action, for which obviously separate procedure will be instituted. Full stop. The court sees no reason why it should therefore interfere with the impugned order on that score. With the above observations, the appeal is dismissed.
Item 47. Please, Lordship, this is the inter-district mutual transfer. Well, this is the thing the one honorable single judge allowed one case and another honorable single judge disallowed this case. This is against which I have come.
This is my lord mutual, the inter-district mutual transfer, which is not in consonance with that is the guideline. Guideline gives that as per the government guideline annexure, that is that annexure 1, there is a mutual transfer can be done of the employee in the same category and same qualification, my lord. In this case, my lord, the petitioner and counterpart applied before the authority that is having the same category. They are level 4, that is teacher, my lord, the regular teacher. And my lord, they have been possessing the qualification. Annex the two judgments of this honorable coordinate bench, my lordship. That is that this is the pure
7, right? And there was a similar matter, sir, where we permitted the council to withdraw and go in an appeal. Go in a review petition.
Review petition.
Before your case is also the same.
Well, in the same.
Permitting the petitioner to withdraw the council for the appellant seeks leave to withdraw the present appeal with permission to file a review petition before the learned single judge in accordance with law. Disposed of is withdrawn with liberty is grateful.
Item 23 also.
1 minute. We'll just call out one by one.
2 weeks after I'm missing the
1 minute, sir. You can't wait for 15 minutes.
Okay.
Call out one by one. Yeah.
Press admission item number 1. My lord, item number 1. On behalf of Mr. D.R. Sundarai, is suffering from kidney disease.
No, you tell us what the matter is. Yes.
My lord, kindly
tell us what the matter is about, sir.
Order of cognizance of the year 2017.
What is the offense, please?
My lord, 363, 366,
376. All right.
POCSO.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. Both matters, the petition is disposed of. Just put down his name. Yes.
Item number 2.
None appears dismissed on opposition.
Item number 3.
Same order.
Item number 4.
Same order.
Item 5.
Same order.
Item number 6.
Item number 6, my lord, at appropriate stage of time.
Yeah, permitting the petitioner to raise.
Item number 7.
None appears dismissed.
Item number 8.
Item 8 to permit to withdraw, my lord.
Permitted
with the liberty to refile cause versus authorized, my lord.
All right, counsel, the petitioner seeks leave to withdraw this petition with liberty to file seek appropriate institute appropriate proceedings if any fresh cause of action arises. This post of is withdrawn with liberty is grateful.
Item number 9.
Please, Your Lordship.
Yes.
My lord, we have not raised the point of sanction in the lower court. So I may be permitted to withdraw with the...
Yeah, permitting the petitioner to raise all pleas at the appropriate stage. All right.
Item number 10.
None appears dismissed.
Item 11.
11. In this case, I am challenging the rejection order, my lord. Dated 26/2/2019, my lord. Annexure 3 at page 12. That is my 311 petition has been rejected.
What's the offense, sir?
Offense only 363.
You want to recall whom?
The witnesses.
Victim.
333.
What is the offense?
363.
363.
The victim must be how young a girl? She's a young girl. What's the age?
Is at the time of occurrence.
What is the girl's age, sir?
Measurement. $22 years. 22 years at the time of occurrence.
No stay was granted. How did he manage? No stay was granted by this court. What has happened in the lower court?
No stay.
No idea.
No stay grant, my lord.
No stay. So by now the trial must be over. If there is no stay, by now the trial will be over.
The informant's daughter was a minor, as per his argument.
That's what I'm saying.
My lord.
Clearly, the impugned order, the order dated by the present petition challenges an order dated 26th April 2019. Sorry, 26th February 2019, passed by the ADJ cum Special Judge Badrak, declining to entertain the application filed by the petitioner accused under Section 311 CRPC for recall of PW3, who was the victim girl in the offense under Section 363 IPC. Stop. The learned trial judge has given cogent reasons why the recall of the witness was not necessary. Many of the questions were not relevant, and certain questions had already been answered by the victim. The court is therefore not persuaded to interfere with the impugned order of the learned SDJ of the learned trial court. The petition is dismissed.
Item number 12.
None appears dismissed.
Item 13.
13, my lord. The petition number 1 is the victim girl. The annexure 2 is the marriage certificate, Nikah Nama. Now they are residing as a husband and wife. Petitioner 2 is the accused person.
All right. Petition number 1 is the wife, and petition number 2 is the accused. They have produced their Nikah Nama. Annexure 2. Counsel for the petitioner states that they are now residing happily together. In that view of the matter, takes from the prayer clause, and all proceedings consequent thereto are hereby quashed.
Item 14.
Not press loss. Not press dismissed.
Item number 15.
15 also in the meantime, matter of hotel, flag K, after filed by the opposite 2 and 3 lordship. Flag K and flag 3, my friend appear for the opposite party.
All right.
Flag K.
It appears that the parties have settled their disputes, as is evident from the affidavits at flag K and Q of the informant side. This is confirmed by counsel appearing on their behalf. From that view of the matter, take from the prayer clause, and all proceedings consequent thereto are hereby quashed.
Item 16.
Item 16 may PLC. The case arising from matrimonial dispute between the husband and wife, my lordship, and the case has been registered under in Annexure 1. The case has been registered, my lordship. FIR has been registered against the in-laws members. There is no allegation against the in-laws members. The present person is the in-laws members.
It's all right.
There was a law of relation between the complainant and the husband, one Pramod Kumar Dhal, my lordship. For that reason, the complainant forcibly entered the house of the in-laws members. Thereafter, the in-laws members admitted, and the complainant and both the husband and the complainant, they have married. Thereafter, the complainant mother's name, the husband recorded his property in his mother's name, but the wife, they wanted to that land property of the dispute was between the in-laws member and the complainant is only that the property, the land record which
the trial is in the year 2014.
That for them that there is no allegation against.
No interim order is there.
The father-in-law, mother-in-law is 73, 70 now is 80 years old, my lordship. 80 years.
Permitting the petitioner to resolve, please. Same. Yes.
Item 18.
None appears dismissed.
Item number 19.
None appears dismissed.
Here, the annexure 2 is under challenge, my lord. A notice issued under section 41A of CRPC against the petitioner. My lord, the 41A notice is generally issued against whom a reasonable complaint has been made. In this case, no complaint has been made against this petitioner.
It's all right, sir. Just have to respond to a notice.
The
All that has been
petitioner,
issued is a notice under section 41 capital A of the CRPC for the petitioner to appear before the police officer. The court sees no reason to interfere. The petition is dismissed.
the petitioner is a additional commissioner.
Stay anyway, sir.
Revenue
There's no stay
Department.
granted by this court anyway, but all by now it will all be over. Yes.
It's still pending, my lord. It's still pending.
Pending is
I
one
think
thing, sir. There's no
charge is-
stay. Anyway, we've dismissed it. All right.
Item number 20.
May I please, your lordship, my lord, raise all the point learned.
Yeah, permitting the
Obliged.
petitioner to raise offense.
Item 21.
Item 21, the petitioner has been acquitted from the charges.
It's dismissed as infractious. Right.
Item 22.
None appeals. Memos taken on record. Not pressed. Dismissed as not pressed.
Item 23.
Same.
Raise all the please.
Permitting the petition.
Item 24.
24 for 2 weeks after I have missing the files,
No. If you miss the file, you say counsel the petitioner states he has missed the file. Dismiss the non-prosecution with permission. Revive the petition if a file is found. Yes.
Item
with the liberty to
25.
file again. With the liberty to file again.
It's over. Yes.
Item 25.
None appears dismissed.
Item number 26.
26 permitted to withdraw.
Permit dismissed as withdrawn. Right.
Item 27.
None appears dismissed.
Item number 28.
28, my lord, liberty to file afresh, my lord. In the meantime, my lord, he has deposited the amount that regarding bank and the present.
Permit you to raise all, please. Permitting the petitioner to raise all.
Liberty to file afresh, because certain developments have been arranged.
Counsel the petitioner seeks leave to withdraw the present petition with liberty to file a fresh petition
Obliged.
if any cause of action arises.
Item
Disposed of is
29.
withdrawn with liberty spread. Memo taken on record. Dismissed as not pressed.
Item number 30.
My pleasure, Lord. Lordship, seeking for quashing of cognizance of order dated 31/3/18.
Permitting the petitioner to raise all, please, with the appropriate institution.
31.
None appears dismissed.
32.
None appears dismissed.
Item 33.
Same order.
34.
Lordship, this is a case arising out of a complaint case, and here also seeking for cognizance. Quashing of cognizance of order dated.
Yeah, permitting the petitioner to raise all, please. Again, this is all right.
Item 35.
None appears dismissed.
Item number 36.
36, my lord, permitted to raise.
Yeah, permitting the petitioner to raise all, please.
Item 37.
None appears dismissed.
38.
None appears dismissed.
39.
Same order.
Item number 40.
Same order.
41.
Same order.
Item 42.
Same order.
Item number 43.
Same order.
44.
Same order.
Item number 45.
Same order.
Item 46.
46 is yours, I think.
No else.
All right. Same order.
47 my lord, is similar to 16, item 16.
47 same. Permitting the petitioner to raise all.
Item 48.
Permit to withdraw, lordship.
48 and 49. IAs, just put the two IAs and dismisses withdraw.
Item 50.
Well, not press.
Dismissed is not pressed.
51.
Lordship, may I please? The matter is regarding the release of the vehicle. Inadvertently filed a CRLMC instead of criminal revision. Lordship filed a conversion application.
Where is that?
Release of vehicle. Lordship.
Where is that conversion application?
Lordship, Annexure 2, Lordship.
No,
Section 2. It's an order, sir.
no, that's a report of the SR, my lord. My lord, saying that the nomenclature is not correct.
All right. You have to file an application. He said he's filed an application for conversion.
Lordship.
Where is your application? There's not.
Lordship will file the application.
He will withdraw to file a.
Counsel to the petitioner seeks leave to withdraw the present petition, liberty to file an appropriate petition in accordance with law. This post office withdrawn with liberty is straightforward.
Item 52.
50, my lords, item 52 may be pardoned. 52, my lords. My lords, notice has been, my lords, returned unserved with noting.
It's all right.
absent.
What's the matter about?
My lords, notice has been issued and stay is granted.
What is
Here,
the
my
matter
lords, the
about, sir?
cognizance, my lords, has been challenged. The opposite, my lords, the complainant filed complainant's main allegation is that the petitioner kidnapped her daughter. But my lords, the annexure 4, that is a charge sheet, is the main vital thing where the police have already, after investigation, submitted that this is completely a mistake of fact and there is no such kidnapping done. And also the victim herself has also stated in 164 statement as well as affidavit that I have annexed under annexure 2 and 3. 2 is the affidavit, 3 is the 164 statement. She has admitted that she was in love with the petitioner and thereafter on her own will she got eloped and married. Thereafter, my lords, after such affidavit and 164 statement, she filed a complaint. She filed a complaint against me.
So that is the petitioner to raise all pleas. This all have to be examined in trial, sir.
My lord,
Permitting the petitioner to raise all pleas at the appropriate stage. Petition is disposed of.
Item 53.
My lord, the matter is infructuous, my lord.
Disposed of is infructuous.
Item number 54.
None appears dismissed.
55.
Your lordship, item 55, I have challenged the annexure 4, your lordship, taking cognizance. There is no, in the affair, there is no direct allegation against the petitioner, your lordship. And he is falsely, and the counter case also is there, annexure 2. My lord, I say that this is a false case and it has been initiated against me, against her. There is no allegation in the FIR. Her name was not found. Annexure 4, the cognizance has taken by the JMFC, your lordship.
Permitting the petitioner to raise all pleas at the appropriate stage.
My lord, at the time of charge, I will raise.
Correct. That's what I've said. Right.
Item 56.
My lord, 56, my lord, matter has been settled and the affidavit has also been filed, my lord. The infant file and
Joint affidavit of compromises on record, counsel appearing for opposite party number 2 confirms it. Accordingly, take from the prayer clause and all proceedings constituting that we hereby call.
Item 57.
Copy the affidavit. None appears dismissed.
Item number 58.
58. Oh, if I may please your lordships, my lord. My lord, a complaint case is initially filed. The learned court directs that you file an FIR. You do the investigation. Final form is filed that no case is made out. It's a false case. On the self-said same allegations, once again another complaint case is filed. Your lordship may kindly have a glance at annexure 12, your lordship. For a moment, my lord. It starts from page 67. The relevant part, your lordship would find at page 68.
Yes. What is the offense under?
My lord, no offenses have not been made out. The prosecution.
What is the provision, sir?
My lord, they are stating under 380-420.
Obviously, contract gone wrong.
Yes, your lordship. Agreements between parties gone bad.
Yes.
Thereafter, my lord, of initial complaint case is filed. The court directs to register the FIR. The final form is filed. The final form, your lordship would kindly see the relevant part, just the page 60, my lord, for a moment.
Yes.
Page 60, your lordship would see
but
that it is.
Opposite parties have not been served, sir.
My lord, yes, they have been. No. Well, notice has been issued. There is a stay, my lord.
80 not back.
80 not back, my lord. We have done our part of the order.
All right. Fresh notice returnable before the roster bench on 25th July. Interim audit cards.
My lord, the interim. Yes, your lordship. My lord, the next item is also in this relation to the same case by another person, your lordship.
All right. Same order next.
I'm grateful, your lordship.
Item 60.
None appears dismissed.
Item number 61.
None appears dismissed.
62.
Same order.
Item number 63.
63.
Same order.
My lord, 63 item, my lord. My lord, the petition challenge
Which item are you in?
63.
63.
63.
My lord, the petition challenge the cognizance order dated 18th in 2019, my lord. And for the offense under section 354A IPC, my lord. And the petitioner is a higher authority of the immediate authority of the complainant, my lord. he lodged a FIR. The ingredients of the 350 is not attracted.
I am for the opposite party. Ma'am. The informant is the subordinate to petitioner. Ma'am. So
What is your stand?
rightly
Cognizance rightly taken.
Well.
No help, sir.
No, Miller, there. Miller, kindly, the page will.
This can't be gone into, sir. Once it is all contested, it can't be gone into.
During the Femeva charge, Miller,
You take, yeah, please.
the petition is limited to.
Correct. Absolutely. Permitting the petitioner to raise all fees at the appropriate stage. All right.
64.
None appears to subsist.
Item number 65.
May I please, my lord? My lord, the matter out of which this criminal proceeding arises, that is out of a civil dispute, my lord. At present, a litigation is pending before the RERA. Of course, those
Who's
facts
the other
have
side?
not been
One
pleaded
Prabhakar
because
Behra.
that is.
1 minute. Counsel for the respondent.
Should I submit?
No, 1 minute. Counsel, the respondent is not appearing. Registry will inform him to remain present to the next date before the roster bench. List on 9th August. Interim order to continue.
Item 66.
None appears dismissed.
Item number 67.
May I please, Your Lordship? Prayer is to quash the DV proceeding pending in the SDJM Bhadrak for trial. Your Lordship, my ground of challenge, just one paragraph, that is Annexure 4, page 28. That entire problem solved there. With Your Lordship's permission, I'm placing 17. Paragraph 17, Annexure 4, page 28.
Yes.
May it be mentioned here that the spirit of Section 125 Criminal Procedure Code pertaining to a wife is for her immediate rehabilitation and financial protection when she is in distress. Such a concept was made a legislature for those dependents that are entitled for maintenance from the estate. Yet it takes much time to settle such maintenance due to various reasons. Thus, in a given case, where final settlement has been made towards the lifetime maintenance, the question of interim maintenance under Section 125 of Criminal Procedure Code does not arise. Therefore, as it is found that petitioner has been settled with one-time maintenance, she is debarred to claim further maintenance. Hence, it is ordered the proceeding is dismissed and contest against the respondent without further. I am for the husband, Your Lordship. Annexure 1 is the settlement that is in Oriya vernacular, Your Lordship. She has already taken one-time alimony. And that is the court order Annexure 4, Your Lordship.
So what is the prayer? I don't understand.
My Lord, prayer is to, again, she has filed the one proceeding under the DV, Domestic Violence Act. That is pending before the SDJM Bhadrak. Now I have filed this case for quashing of that DV proceeding because matter has already been settled. So this is not maintainable at all.
But who is appearing for the wife?
My Lord, the wife, Your Lordship, name has been reflected, the name of the advocate, but there is somebody, Mr. Vijay Kumar Mishra.
Mr. Vijay Kumar Mishra, counsel for the respondent, is not appearing. Registry will inform him to remain present to the roster bench the next date. List before the roster bench on 16th August.
Interim order to continue. Interim order is there.
Item 68.
May I please, Your Lordship? It's a matter regarding quashing of FIR under section 306, my lord. The FIR is of 2012. The CRLMC is pending since 2019. And Your Lordship, on the basis of the direction of this Honorable Court, the IO filed affidavit on 13/12/2019 that the present petitioner is not cooperating. And basing on that, on 7/12/2021, this Honorable Court passed the interim order. Since then, I am approaching repeatedly, but till date, no charge sheet has been filed. As per my instruction, my lord.
It's all right.
So, Lordship, may 2 weeks time to ascertain the present.
No, it's all right. Permitting the petitioner to raise all pleas at the appropriate stage, the petition is disposed of. The interim order is vacated. All right.
Item 69.
Made please, Lordship. Well, Lord, here the offences of punishable under Factories Act. Well, Lord, what has happened? Here the point is that the managing director has been added as accused without the company being made an accused, which is clearly covered by Sharad Kumar Sanghi versus Sangeeta Rane case in the Honorable Supreme Court 2015-12. Right. So, my lord, that is one. The copy is here. My lord. And another.
That's all right. That's all. That's enough, sir. What about the seal cover? Some things come in seal.
But a
a
letter has been received from the Deputy Director of Factories Boilers. Flag B.
Flag B. What is the letter? Judgment copy is here. Hello, 9 year old can live. I'm sorry.
All right. You see, the complaint was filed against the petitioner in his capacity as managing director of United Breweries Limited, UBL, but not against UBL itself. In view of the law explained by in Anita Hada versus Godfather Travels and Tours Private Limited 2012 ISC 661 and reiterated in Sharad Kumar Sanghi versus Sangeeta Rani 2015-12 SEC 781. Aforementioned complaint insofar as it concerns the present petitioner is hereby quashed. A complaint criminal case number 2CC CC case number 78 of 2017 pending before the SDJM Khurda as far as it concerns the present petitioner is hereby quashed.
Deeply, please.
Nothing here. Contents produced, it be kept on file.
Item 70.
Nana paste dismissed.
71.
Same.
72.
In the meantime, the matter has already been settled between the parties, my lord.
All right. It is stated that the parties have settled the dispute. Counsel for opposite party number 2 confirms this position. An affidavit has also been filed by opposite party number 2. Consequently, take the prayer clause and all proceedings constitute that were hereby quashed.
Item 73.
Nana paste dismissed.
74.
74, may I please your lordship? I am on the same. May I please your lordship?
Yes.
The prayer for quashing of cognizance order dated 22/1/2019 on the ground that the dispute between the parties is civil in nature. So continuance of such proceeding amounts to abuse of process of court, and therefore I pray to secure ends of justice. The cognizance order may be quashed on the ground that
you are for the opposite party.
Yes, well, I am for the opposite party.
What is your stand?
My lord, the Lord Magistrate, after taking properly scrutiny, the competition directed the police to register the case under section 156 clause 3 of the service, my lord. Then the Lord Magistrate also.
After the injunction order, he has filed.
My lord, if he has any allegation and during the trial, they may be pointed out that.
All right. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is disposed of. All right.
75.
Disposed of.
Nana is dismissed.
76.
76, my lord, the petitioner died, my lord.
The petitioner is stated to have died. The petition is dismissed as having abated. Right.
Item number 77.
Nana is dismissed.
Item 78.
Nana is dismissed.
79.
Same order. Actually, the memo is taken on record. Dismissed as infractious.
Over 80 already.